31. With the consent of the other side, this matter may be come up after 2 weeks, Lordship.
Have you given your mention slip?
I have not given.
This is the problem. There's already a notification. You are aware of that notification.
Lordship.
Then you are appearing on behalf of?
I am appear for respondent number 4, Lordship. I have taken the consent of the petitioner.
From next week, I'm not going to adjourn matters unless you give mention slips. Your good name, please.
D. Borpujari, Lordship.
On request made by MS D. Barpujari, that is counsel for respondent number 4. Is the matter after
2 weeks, Lordship.
2 weeks.
Obliged.
May it please your lordship. My lord, if your lordship permits, this matter may be listed tomorrow as motion.
Why?
My lord, the urgency is that there was a challenge to the provincialization. Considering the teacher people ratio, this honorable court directed the director whether find out, considering the number of students, whether you can create an additional post for the petitioner. That was the direction, and total 5 teachers were already provincialized. He was the 6th one. What the director has done, though actually under the teacher people ratio, it should have been 8 posts. Only 5 were there. So that's the reason the court, when both the side argued the case before the court without going into the merit, asked the director to find out whether additional posts can be created to adjust the petitioner. Instead of that, he cancelled my provincialization. And there is not even a whisper of reason, my lord, in the order. After 30 years, I got my service provincialized. What was the direction that was misconstrued? I don't know how he has come to the arrival that one person has to be removed. Instead of creating additional posts.
When was the order passed?
My lord, order was passed on 17th, not communicated to me. I received it on last Saturday, my lord.
Then we can have it on Monday.
Monday, I will not be here, man. That week, I'll be out of station for medical purpose. My lord, my provincialization is cancelled, though I'm still working.
Friday.
Can't we have it tomorrow, my lord? A chance?
Tomorrow will be difficult.
Friday. Deeply obliged, man.
May I please, your lordship? My lord, I have a similar prayer for motion on Friday. My lord. Obliged, lord.
May I please, your lordship? I beg to mention item number 2. In this case, lordship, additional affidavit has been filed yesterday, and some other writ petitioners, they have also filed a separate writ petition raising the same grievance. So let all these matters maybe come
Okay,
together,
wait for your turn.
lordship.
You wait for your turn.
Lordship.
I recommend for listing motion for Friday.
Friday, Monday.
No, it is filed on 7.
Monday.
May I please, your Lordship? Lordship, I beg to mention for listing for admission, Lordship.
Yeah, 23rd.
Obliged.
Yeah, please, lordship. Lordship, I beg to mention a writ petition for listing, lordship. Monday, lordship.
What, motion or admission?
Admission.
Okay. 16th.
Deeply placed, lordship.
May I please, your lordship? Lordship, I beg for listing to writ petition, lordship, in admission, lordship.
25th.
Obliged.
May it please, lordship. My lord allowed me one motion writ petition for listing today, my lord. It
Why?
is already, my lord, the transfer matter, my lord. Your lordship allowed yesterday for listing today. Today, my lord. They already numbered but not listed, my lord. So,
Tomorrow we'll have it.
no, my lord, tomorrow is the last date, my lord, for joining. Otherwise,
I don't like this type of unlisted matters.
my lord, then my lord, my lord, the other 2 petitions, same petition, my lord.
Okay.
At 2, my lord, other 2 petitions also, same petition. My lord.
3 petitions.
No, my lord, one already your lordship allowed yesterday, that is also not listed. Today I'm playing another 2 same petition.
Another 2.
Yes, lord.
Oh.
That another 2 may tomorrow, my lord. Only who say your lordship allowed, that may be today.
Eliminate the second date.
Second date.
Copy দিবা, copy at দিবা, copy
তো already served.
Get to the difficulty. You will start copy there. Lordship.
No, already served yesterday, I have filed, not today. Filed I have the yesterday.
Then inform the detail.
Oh, okay, I'll inform.
Sorry.
My lord, your lordship is permitted for today, that will, that will-
Only one matter.
only one, other tomorrow, my lord. I am.
Item one of the motion.
My lord, in this case, instruction was sought, my lord. This is the second date.
My lord, I have to receive it. Regarding my
What is the demerger?
My lord, earlier there was a order for merger that we have challenged, my lord.
And then
So-
you have issued the,
yes, ma'am. Merger has been cancelled.
where's the cancellation order?
There is demerger, madam.
Huh?
Demerger is merger.
They had an inquiry and my lord, in the inquiry, there is a report.
Where's the school?
Yes. My lord, the demerge order has not yet been issued, my lord.
Oh,
Yes,
Just
my
been
lord.
ordered.
Yes, my lord,
Yes.
your lordship may dispose of.
her term as SP Chowdhury and the counsel for the petition. Mr. G. Bekul and the standing counsel, Elementary Education Department, has produced an order dated 3/8/2023, by which the merger of number Makili Daspara LP School with Makili Kalitapara LP School has been cancelled. Stop. In that view of the matter, nothing survives in the present petition. Accordingly, this petition is closed. The order dated 3/8/2023 is placed on record.
So. In this matter, my lord, we were directed to obtain instruction, we have got instruction. The lump sum cases, whatever, my lord. Fact is, the state selection board, my lord, has advertised for selection of that teacher for, my lord, a 6 scheduled area. So advertisement made and accordingly they have applied. They have applied, my lord, first of Hindi was there, but subsequently a corrigendum was issued, Hindi language is not there. Anyhow, my lord, they have appeared in the examination. We have given the OMR and the question paper. They done it. They appear and done it and completed. When the evaluation was done, my lord, evaluation was done, expert body, a committee was, my lord, constituted by the selection committee, having the experience of the education in the campus, my lord. So they found that some 3 questions, one question is wrong, that is they have given G, and another 3 question is A, B, C, D, like that, they have said. And they decided, well, whoever is attempt this question paper or not, irrespective of attempting or not attempting, they will give the marks. Accordingly, they have given all the marks. But petitioner have failed. They had to acquire the 83 marks. They have got the petitioner got 78 marks. That is the case, simple case, my lord. Already wrong question, they have given marks to all given. There is no any discrepancy.
Not only that, lordship, in respect of this writ petition, I have filed an additional affidavit showing that not only these wrong options, there are questions with wrong answers has been given.
Have you given a copy of the additional affidavit?
Yes, lordship, that is filed yesterday. Probably they have.
We have got
got-
received, my lord. But
that issue, that wrong options and wrong answers, that I got it after filing of the additional affidavit. Here in this additional affidavit, I placed on record regarding the wrong options, and the wrong options which has been cited by my learned senior friend on the other side. He said that wrong options, as only 3 wrong options has been given, but it is totally incorrect, if I may say, because there are wrong options in my writ petition. The RTI reply, the OMR sheet and the answer key says that it shows that 5-6 wrong options have been given.
So,
These 5-6 number has not been added.
so where's your additional affidavit?
Lordship. That is filed on yesterday, Lordship. Let it come on record. Lordship may fix it on Friday. It will come on record, Lordship. Our Bora, Lordship.
Lordship, kindly see.
And another repetition has also been filed. It is within the same grievance. Let all this come on record and Lordship may fix it on Friday.
Lordship,
Decided
kindly
the whole issue.
Page 12. Writ petition, paragraph 6.
Before going into the
Yes,
merits of the
number one.
case now, at this stage, Lordship. What I am praying is,
Let him, let us have see
Yes.
the additional affidavit filed. by-
let me bring on record.
No, but
You serve a copy or on
Yes.
the.
No, we have already solved it.
Interim may not be continuable. Interim is till today because they have already failed. We can produce all these things. But it is these are the questions are wrong and some are same
I'm
question too.
fixing it on Monday. Let
Yes.
us see on Monday. We'll
Yes.
dispose of it.
Because those who have passed, they are waiting for getting the budget.
Yes, by Monday, if
No,
Mr.
our Bora, Lordship.
Our world and the council of petitioners submits that he has filed an additional affidavit. On? When did you file your additional?
Yesterday, Lordship.
On 8 August 2023. You just need to verify and place the save on record. He found in order. List this matter. Along with WBC number.
The filing number I have, Lordship.
Oh,
It was-
that's filing number, then we'll list
That-
this matter again on 14th.
Lordship.
interim may not be continued because
Lordship, interim has-
Interim will continue till Monday only.
no,
Lordship.
how they will affect it if it is not continue, my lord. Those who have passed, let them given the certificate, my lord. They will get it. If they pass, my lord, after hearing that, they will get a certificate. So why this interim is necessary? If suppose they passed,
Because
then they will given the certificate.
because if they do not
No,
issue
no,
me
my
the
lord. Why this is not a PL? But other students are suffering. They are not made party.
what I am submitting
No,
to your
no, no.
Lordship
I
is that
don't agree with you, my lord.
if they
Interim
do
is not
not-
necessary.
if they do not issue me the certificate tomorrow, suppose they are issuing the certificate by tomorrow to other candidates, and they are not issuing to me tomorrow. And after 15 days or 13 days, they are issuing me, or there is no time limit given by them that you will be getting the certificate by tomorrow or the day after tomorrow. And after day after tomorrow, if they issue an advertisement for filling up the post for appointment, what will happen to me if I even get the certificate?
Matter is pending, lordship will direct it.
The
If they,
interim order is still on
no,
Monday,
if they
Lordship.
passed, if they
It's
passed,
up to Monday only.
Yes.
It's the matter on 14th, interim order passed till
no, how he is affected, my lord.
till the next agenda.
Obliged. Much obliged.
3.
Also, in this matter, we're supposed to file an additional affidavit. We're filing is today itself, my lord. And so let the let the affidavit come on record, my lord, on Friday or the next Monday, my lord.
My submission of the Lordship, I am for a private respondent. Lordship has passed an order directing the Director of Secondary Education BPC to pass a taking order, which was set aside by your Lordship. And thereafter, Lordship on last occasion passed a status quo order. Status quo means he has been removed from the post of principal and taken back to the original post. That order was not been stayed, and he's still not giving the ending of charge.
When did you file your additional affidavit?
I'm filing it today itself, my lord.
Okay, Mr.
As Chaudhary.
S. Chowdhury on the council for petitioner submits that is filing an additional affidavit within the course of the day. Accordingly, list this matter again on 16th.
My lord. There's a status quo order is there.
So the slow order passed ready to continue till the next. agenda.
Obliged, my lord.
4.
May it please your lordship. Lordship, the petitioners are applied for assistant teachers pursuant to an advertisement in February 2023. The advertisement eligibility criteria, it was as in the rules: 100 marks for HSLC exams, 100 marks for diploma, 100 marks for TET, and other certain other 30 marks which are not contentious or in concern here. We applied. Lordship is already aware, there is an Assam State Open School. So when you pass your class 12, initially Assam State Open School started to, by way of a correspondence course, to give access to education. People from outside could apply and do a course sitting at home. It also provided for an improvement scheme. So if I have done class 12 in the regular board, I can apply for improvement and get a better score. Throughout till 2023, there was no issue. They allowed us to participate. Our marks as we got in the open state school were calculated. In 2023, the impugn notification, they say, sorry, the Assam State Open Scheme is applicable only when the qualifying exams of class 12 and the subjects that you take in open school are the same. So supposing I have taken 5 subjects in my class 12, I can only take an improvement under the open school scheme in the same subjects, not otherwise. And that is not how it's reflected in the scheme. They changed that. Lordship, similar matters have come up before your Lordship, where they said that, Lordship, can you take a look at your order? Lordship, what the problem is that they are saying that when this particular merit list is gone, we are excluded. But there is, the last time they came up and said that there'll be more vacancies. And in that ensuing vacancies, we could make out our case. Lordship, there are 3 other cases pending. My prayer is Lordship may decide this issue once and for all and hear it before the new vacancies arise. And again, the same situation is arises there. So issue really is whether, Lordship, may I take you through the scheme?
Yes.
Yes, your Lordship. Lordship, the scheme is at page 63. Lordship has page 63?
Yes.
Yes, it's 30th July 2022. And Lordship, basically it's saying that for dropouts, etc., the scheme is here. Lordship, the next page is what is relevant for us, page 64, the profile. Introduction is that Assam State Open School is an apex body of Assam Higher Secondary Education Council, and it goes on. And Lordship, what we are concerned with is 65, 4th paragraph, right on top.
Well, before my learned friends start, may I submit one thing? This notice was issued by Assam Higher Secondary Education Council. So they have made a party in Respondent 4 that their name is not reflected in the cause list. They have to be present before this court.
Assam State?
Higher Secondary Council.
Assam?
State, the Higher Secondary Education Council. They have made party in Respondent 4 issued by the Secretary Assam Higher Education Council.
Assam State.
If necessary, we will take steps.
Page 63 make issuing authority. Assam Higher Secondary Education Council.
Their party.
They have made party in Respondent 4, but their name is not reflected.
Do they have a standing council?
Yes, Lordship. And their name is not reflected in the cause list also, Lordship.
Assam
Have you
State?
served copy?
I don't know whether they have served it or not. But
Because otherwise we cannot file.
No.
their name is not reflected. And it is an element, and more so, Lordship, this is the director of elementary education is a party, but here it is shown secondary education, Lordship.
We take steps. Lordship may hear us and then we,
In their presence, Lordship, here, let it fix on Friday or Monday, Lordship.
Lordship, I'm pressing, Lordship, the problem is this. We've already lost our case in the last merit list because we didn't get any order and it's over. They kept going on that there will be more vacancies. Now, we don't know when that is. It's imminent. So it shouldn't happen that in the meanwhile, this issue remains and again we are prejudiced. So my only prayer is, Lordship, they have allowed us to appear. They have taken money from us, allowed us to appear in different subjects. And they're reneging from that now in 2023. Lordship, therefore, what our main prayer is that in the ensuing advertisement, we must be again prejudiced. So let this issue be once and for all decided, whether actually it's the same subject or are we allowed to choose subjects up to 2 different from what we appeared in class 12. That is a short question and it requires interpretation really of the scheme.
But right now, there is no process is continuing or initiating, Lordship.
Lordship,
So they can wait for Monday, Lordship.
okay, Lordship, Monday is okay, Lordship.
Let the transfer for higher secondary education. They
Okay, we will take steps.
Heard MS
G. Goswami.
G. Goswami is responsible for the it is still directed to reflect the name of the standing council. Assam
Higher
Higher
Secondary
Secondary
Education Council. Yes, Lordship.
Process. And list the matter again on.
And in the costliest lawsuit, in place of secondary education, it should be elementary education lawsuit.
14.
And in place of secondary education lawsuit, it should be elementary education lawsuit. That should be corrected in the cost list.
Registry is also directed. That the name of the elementary, studying cost of elementary education department should be reflected in the cost list instead of secondary education.
Lordship is sitting on Monday.
Monday.
Oblige your lordship.
5.
May I please, lordship? Look at this case, lordship.
I have the instruction, my lord.
Instruction of software regarding whether there is any power entrusted to the deputy commissioner to make some.
Gazetted notification, my lord. Second page, my lord.
Yes.
My lord, perhaps this notification, here lordship, although the grade 3 and grade 4 post lordship were entrusted to the deputy commissioner, but here lordship in
It says
consultation.
grade 3 and grade 4 of all categories, including junior engineer and medical staff.
Yes. My lord, last 2 lines lordship. And the same department within the same district and same department in consultation with the district head of the concerned line department of the district, so that there is better delivery of public service.
So your petitioners have been transferred within the same department.
My lord, without any consultation with the district officer.
How do you know that?
My lord, another one, my
Yes,
lord.
that is your lordship will find.
I give a single copy, my lord, that order from the inspector of schools, my lord. Prior to passing of this listing of this case, my lord, they were already relieved from their concern.
No, lordship.
That order I have placed, my lord. Another one.
Lordship.
I've got only one order.
My lord, we have not served this copy.
Oh,
I don't.
Status quo order was passed on 3rd August, my lord, and that was passed in 1st of August. My lord.
My lord, we have not served.
Released from the office of the inspector.
We have not
So in
served that.
fact, that status quo will affect them, my lord.
My lord, we have not served this order, lordship. They are saying that we have been released. We are, my lord, discharging duties. I have brought that lordship, some of the petitioner lordship were on leave, and they joined in the service yesterday, lordship. And they have lordship joining.
you have been released.
No, lordship. Lordship, that is the order that is on their office record, but that was not served to the petitioner. Petitioner are still continuing, lordship. That is, lordship, I have given the attention of the petitioners, and some of the petitioner lordship were on leave, and their lordship joined yesterday in the region in their duties, lordship.
Apart from that, my lord,
I have
fully
given-
authorized, my lord. There's the power to transfer.
My lord, if your lordship kindly come to the impugn order, page 29. There is no whisper that the district authority commissioner has consulted with the departmental authorities. There was no proposal from the departmental officer. My lord, page 29 is the impugn order. lordship.
That I've seen.
My lord, there is no whisper. That the-
See here, the issue is that you have said that the deputy commissioner does not have the jurisdiction.
My lord,
Correct?
my lord,
The jurisdiction part is already covered by
My
the
lord.
gazette notification.
my lord.
What else are your other grounds?
My lord, this is not, lordship, this copies was not available with me today, lordship, just I have seen. That, my lord, the deputy commissioner has been entrusted to make transfer, lordship. But that is, lordship, with the consultation with the district head of the concerned department, lordship.
Yes.
whether this lordship transfer order was issued with the consultation of the district head of the lordship department. That is not reflected in the impin order.
Not necessary.
My lord, let them file affidavit, lordship, we will, lordship. Moreover, lordship,
It is in public interest.
my lord, moreover, lordship, what the present petitioner lordship, they are serving in the inspector of school lordship. In
See,
the office
the
of the,
order says that you have been relieved on 1/8. Number two, the deputy commissioner has been given the power, has been empowered to cause transfer of all grade 3 and grade 4 staffs, including junior engineer and medical staffs.
my lord, that is correct.
You belong to which post? Which
My lord,
group?
we are lordship, lordship employees of the office of the inspector of school lordship.
That's why.
Grade 3.
Grade 3
Great
post,
post,
grade 3 post.
no doubt, lordship that.
Then
But my contention is that lordship. So
the
far
issue
the-
is this.
my lord,
Your only ground in this writ petition is that deputy commissioner does not have the jurisdiction,
my lord,
correct?
my lord. This is the first ground, and second ground, lordship. There was no proposal from the departmental authority.
Where's the second ground?
Yes, lordship.
Where's the second ground taken in your writ petition?
My lord, paragraph, page 10, paragraph 9, lordship. That from existing 7 numbers of senior assistant in the office of the inspector of school, 5 of them has served to be transferred to different schools, keeping only 2 senior assistant in the office without any consultation with the inspector of school. Such arrangement would also cause serious inconvenience in the affairs of the office of the inspector of school due to lack of sufficient number of senior assistant that was never looked by the respondent number 3.
How do you know that there was no consultation?
Yes, the impin order itself saying, lordship.
That is not necessary to reflect everything. my lord.
My lord, may I submit, lordship, this matter may be taken after some time, Mr. Senior, lordship, senior counsel, MPS should really appear, lordship, in this case.
In fact, that status quota will not allow them to join.
Yes,
my lord,
no,
because they
lordship,
have already been released.
I have submitted that documents,
I'm
lordship.
trying to help my
We are
mother.
still working. I have given that set of documents, lordship.
Okay.
After some
You
time,
want
lordship.
some time? We'll give you- What is this?
My lord, this is the attendance, lordship. We are serving in the office of the inspector of schools, and the 3 petitioner, lordship, page 2, 3, and 4, lordship. They were on leave, lordship, and after that, lordship, they rejoin in their duty tomorrow, yesterday, lordship.
No, they are already released. my lord.
No,
So
You're
they
already
cannot-
released.
they cannot-
No,
they
no,
cannot
so
join
that-
again, my lord.
There's nothing
order has
much-
not been served to the petitioner.
There's
After-
nothing much in this.
Six.
May I proceed? My lord, the matter relates to the post of the school teacher. My lord. My lord, what happened in this case, the husband of the petitioner,
1 minute.
husband of the petitioner, my lord, was the school teacher. He died in harness. Thereafter, the petitioner was appointed on compassionate ground. She was working, my lord. Meanwhile, the head teacher of the school retired, and the petitioner was appointed as the head teacher with all power, including financial power. She was discharging. Meanwhile, what happened, my lord? The petitioner fell ill. She fell ill. She submitted petition for granting earned leave. Earned leave was also duly granted. During that period of her falling illness, my lord, the assistant teacher, respondent number 8, was allowed to hold the charge of in-charge headmaster in the absence of the petitioner. Petitioner is the headmaster. When she went on leave, the assistant teacher was allowed to hold the charge of in-charge headmaster. Now the petitioner has recovered. She has assumed her duties. But the assistant teacher, he's creating trouble. He's claiming that I am the headmaster. No, my lord, the impugned order, your lordship will find, my lord, annexer K.
Which
Page, my lord, I'm Given the page, my lord. Oh. Page, my lord, your lordship will find a page. That page, my lord. 57. 57,
Yes.
Annexer K, this is the impugned order. By this order, my lord, when the petitioner went on leave, the assistant teacher was allowed to hold the charge of the in-charge headmaster. On the basis of this order, now he claims to be headmaster and disturbing the regular head teacher of the school. Representation has been filed, my lord, before the commissioner. That has not been disposed of. That's lying pending. So, my lord, my humble submission before your lordship, the representation may be disposed of by
Yes.
the head of.
My lord, can you go to page 10 of the petition? For error number 14, my lord. Here, petitioner stated that guardian and guardians of the student were touching her.
Page
10.
At the instance of the in-charge headmaster,
My lord.
he was encouraging the guardians. He's mobilizing, my lord, against the regular head teacher. So let it be decided, my lord, by the head of the department. We have submitted the representation.
Yes.
Yes, my lord. My lord, this is my lord, kindly to notice then on exactly interim pair may be considered. Because
Not
private
the
respon-
interim player, we can dispose of this writ petition
Yes, for sure.
directly them to consider a representation.
Yes, representation is pending, my lord. Oh,
Heard, Mr.
Jamullah.
J. Mullah, consider. Stop. The petitioner was initially appointed as teacher in 617 number Kayaska Gaon Tribal LP School, Gobardana, on compassionate grounds. Stop. By an order dated
My lord,
27/9/1995, ma'am.
is it 95 or 98?
But my petition is 95.
You are appointed as teacher as what? By which order?
yes, my lord. She was, my lord, kindly turn to annexer A.
Hmm.
In paragraph 4, we have stated. In paragraph 4, my lord. In paragraph 4, we have stated she was, my lord, appointed by order dated 27/9/1995. It is annexer A. Annexer A, lordship. Annexer A, your lordship will find at page 21. This is the initial order, my lord. Thereafter, my lord, she passed the basic training. It was a condition. She has to pass.
Stop. Now continue. Then what happened?
After passing, my lord, the condition, basic training, her service was
Thereafter,
regularized.
The petitioner appeared, pursued the basic training course, and she completed the same on 22/11/2021. Stop. Accordingly, her service was regularized by Her service was regularized.
Para 6, your lordship will find, para 6, by order dated 29/1/2002. In para 6, we have a statement.
By order dated. Twenty-nine 2002. Stop. In the meantime, the head teacher of the said school retired from service. And as the petitioner was the senior most teacher, assistant teacher, comma, she was appointed as head teacher. No. She was appointed as
In paragraph 7, your lordship will find.
she was allowed to hold the charge of head teacher, isn't it?
Yes.
With financial authority of the said school by an order dated 31/2008. Stop.
Other paragraphs, my lord,
In the
8, 9,
meantime,
10, not relevant.
the petitioner felt sick,
Yes, paragraph 12, we have stated.
and therefore she had to take earned leave. From which period?
My lord, paragraph 12,
She applied for earned
Yes.
leave.
from 1st February 2023
22/5/2023.
to 31st May 2023. In paragraph 12, we have stated.
No, don't say like this. Where's your application for leave?
Annexure I and J. Annexure I and J. Your lordship will find. Yes, which I.
Okay. Then in the meantime, the petitioner
Annexure,
felt sick
Annexure I, page 44.
and she could not attend her school from 1/5/2023 to 31/1/2023. How can it be 1/5/2023 to 31/1/2023?
No,
Yes, sir.
my lord, kindly see paragraph 12. We have stated. Paragraph 12. From 1st February
She could not attend
2023.
She could not attend to her work from 1/2/2023 to 31/5/2023. Accordingly, she made an application for granting earned leave for the said period on 22/5/2023.
কি করেছে এটা? Just today থেকে।
Thereafter, the earned leave was granted and the petitioner was directed to resume her
Resume.
duty as in charge head teacher,
Yes.
as in charge head teacher.
I am not in charge head teacher, my lord. I am regular head teacher.
As head teacher. Stop. During the absence of the petitioner, during the absence of the petitioner from work, the respondent number 8 was permitted to hold the charge of head teacher of the said school,
In-charge head teacher.
was allowed to hold charge of in-charge head teacher of the said school, along with the power of financial transaction on temporary basis by an order dated 6/12/2022. Stop. See, one thing is not very clear. You were sick from 1/2/2023. Correct.
Yes. 1st February
To
23 to
31st May.
31st May 2023.
Our order was passed on.
The in-charge teacher
Yes.
permitting the respondent number 8 to hold the post of in-charge head teacher
In-charge.
was issued on 6/12/2022. How can it be? That time you were working.
না না একটু তো হেড টিচার করবো যাবে।
It cannot be. There must be something else. I can't direct for consideration of
বেটার বেয়ার পরপেটা রোড 29 নভেম্বর।
hurt.
It is
Mr.
annexer.
So-and-so.
নাকি অ্যানেক্সার কি তো?
I'll issue notice.
হুম,
Issue notice.
হুম।
Mr. G. Bekul, understanding counsel,
কি করি?
elementary education,
জানাই।
appears for respondent number 1 to
1 to
7.
7, man.
1 to 7. Stop. Petitioner to take steps for service of notice on respondent number. Here also, everything is wrong. You,
Yes.
this
This one is wrong, man.
serial number is also wrong.
সিরিয়াল নাম্বার রং।
Proposed title. Something is wrong in your writ petition. You withdraw this and file fresh. Otherwise, you'll have to file an amendment, IA for.
Application for leave is also wrong, mama. My road, wrongly typed, man.
Yes.
সিরিয়াল নাম্বার কি দিছে? সিরিয়াল নাম্বার 4 হয়ে আছে 7 এর পিছন।
Everything is wrong in this writ petition. You withdraw and file afresh.
মানে I may be allowed to correct it.
No, you cannot correct it. There's a notification now. You'll have to file an IA for amendment.
কি করবে? উর্দু করে ফাইল করবে ফ্রেশ। হ্যাঁ এই
I'll give you liberty to file afresh.
Mallet only 8 should be put here.
That I cannot. There's already a notification that nothing can be corrected by hand anymore.
We may be allowed to do, my lord, with liberty.
With liberty. Mr. So learned counsel for the petitioner press for withdrawal of this writ petition with liberty to file afresh. Mr. J. Bikul, standing counsel appears on behalf of the secretary, elementary education department. Writ petition is dismissed on withdrawal with liberty as right for stop. I also, in view of order passing on that, I stands disposed.
7.
Yes.
May it plead your lordship. Lordship, this matter pertains to compassionate appointment. In this case, lordship, the petitioner submitted the application before the DO on 29/10/2009 along with all the documents. Accordingly, the DO
When did your father die?
father died on 18/7/2008. Lordship, according to the DO on 5/11/2009, submitted the particulars before the DLC. Lordship may come to the page number 16, Annexure D.
Yes,
Lordship, this is clear from the particular that that it is submitted by the DO that the applicant applied for the compassionate appointment on 29/10/2009.
where's your name?
In the last, Putul Borua. But Lordship, but even after the submission of the particulars, the case of the petitioner has not been considered by the respondent authority till that.
DLC.
Yes, Lordship.
Yeah, Baro.
My lord. My lord, let the next step be, my lord, who is enclosed by the petitioner, that is the not communication to the deputy commissioner of DLC, my lord. That is the interdepartment department statement. And matter, my lord, that whatever the petitioner died in 2008, my lord, they are coming after 15 years for compassionate appointment, my lord. And there is a no explanation in the petition, my lord, why such delay occurred, my lord.
Yes,
And application also not enclosed, my lord.
the delay. 2009, you make your application, nothing happened. Today is 2023. What is the ground for your delay?
My lord, may I check this?
Yes,
My lord, the petition was filed on, my lord, the application was filed on 2019-2009. That is admitted position, my lord. And it was submitted before the 5/11/2009 in the DLC, my lord. It is the, my lord, respondent authorities who is not taking action, my lord.
so why are you coming to court
No,
so late?
My lord, we have approached time and again, my lord. We have approached your lordship. We have given statements.
Where? You have approached this court earlier,
No, no, no. We have not approached, my lord.
yeah? That is what I'm asking you. Why have you come so late? 2009 matter, you're coming today.
Yes.
Have you given your explanation?
My lord, para 6, my lord. Para 6, we have said.
That is not an explanation.
My lord, we have approached the authorities, my lord.
Keep on approaching them. Why have you come here?
My lord, that is true, my lord. But the petitioner, my lord, they are not so aware about the law. It is
That
their,
is not an excuse.
that is not an excuse. However, my lord, it is the respondent authorities also that it is their duty to, my lord, take the action.
At least
We didn't want-
check up whether the DLC has considered, they must
Yes.
have considered the matter.
And my lord, let them petitioner file the original application along with their receipt by the concerned authority.
No.
Where's
Because my lord, this annexure D, my lord, does not making any prima facie that made in the.
Where's your application? Where's your application?
My lord, application, generally the petitioners, they don't keep the application, my lord. It is the, as on date, they file the, my lord, it is not the general, the poor people, they don't know anything about that, my lord. They files, my lord, it is admitted position from this, my lord, annexure D, my lord. The application has been received on,
I think you should file an additional affidavit explaining your delay.
delay, my lord, I'm accepting, but whatever.
That you'll have to explain. You have not explained in your writ petition at all.
Delay, I'll explain, my lord, by filing an additional affidavit.
J. Payang, Learned Counsel for Petitioner.
Let them also get instruction, my lord, in the meantime.
Is
if it
allowed, how much time?
1 week, my lord.
1 week time. To file an additional affidavit explaining the delay in approaching this court. Stop, list the matter after 1 week.
Obliged. In the meantime, my lord, if my learned friend can get
That you
instruction,
can take your instructions.
yes.
But
Whether if it is considered,
can be, my lord, obtained by the concerned department. Because my lord, this is departmental interest statement.
No, just check out whether the
My-
DLC has considered the case.
My-
in the meantime, that's
Obliged.
obliged.
5,
I'm sorry, my lord, I was on legs and I'm.
My lord,
There's an issue
my lord.
where you've taken a ground that the deputy commissioner does not have the jurisdiction to issue the
Yes,
order.
my lord.
There's already a gazette notification authorizing.
My lord, I like to have a copy, my lord. Your lordship will kindly give me a moment, please. Within the same district and same department, in consultation with the district head of the concerned line department of the district, so that there is better delivery of public services. My lord, if this is seen, my lord, the education department, the inspector and the director was never consulted. That is, my lord, that is reflected in the order itself, my lord. If your lordship comes to the impugn order,
It is not necessary to be reflected in the order. The only thing is that they have been transferred in the same department. And they have been transferred by the concerned district commissioner or the deputy district commissioner. And he had the jurisdiction to do it.
my lord, there are two aspects in the matter, my lord.
Hmm.
So far as this notification is concerned, this has, my lord, apparently given the deputy commissioner the authority to transfer within the district. But my lord, there is a rider that the district head has to be consulted. This is one rider. And secondly, my lord, about the release, it has been said, my lord, the release order has never been served. Let them show that it has been served on us. Now, my lord, if your lordship kindly comes to the impugn order at page 29.
Hmm.
This is the order by which this, my lord, senior assistants have been transferred. Then if your lordship comes to page 31 of the original, my lord, this original is page 30. There, my lord, the consultation is not reflected, my lord, with the director. Only copy has been made. Therefore, my lord, perhaps your lordship may like to see the records, my lord, whether there was consultation or not.
It is not required to be reflected in the order. Obviously, it would have been a consultation.
Even. Otherwise, my lord, how the district commissioner will come to know how many vacancies, who is working where? And otherwise also, my lord, transfers or orders, my lord. Well, that cannot be challenged in jurisdiction, my lord, because no statutory right is proven. Even the FX court has helped, my lord. First, let them join, my lord, to the present place of posting. Then
My
they
lord,
come.
the another point that I raised, my lord, by moving the petition is that they are in the, my lord, in the service of they are in the establishment of inspector of schools. Their service, my lord, conditions are governed by a particular set of rules. And when they are posted in schools in remote areas, my lord, leave the remote areas, their services will be governed by the, my lord, school rules. That is a, my lord, change in the condition of survey,
What I can do, I can tell them to file an affidavit,
my lord.
but you'll have to go and join since release order has already been issued.
Release order,
It will be in your interest only,
my lord, release orders have not been served on us as yet.
whatever it is,
My lord.
whatever it is, you'll have to join to it and then come to court. That is the settled position of law insofar as transfer matter is concerned.
At least, my lord, let me have the instruction at a short date, my lord, because the
Okay. On your request, I'll list it on Monday and then heard Mr. M.K. Chowdhury, Learned Counsel for the Learned Senior Counsel, assisted by Mr. A.K. Das, Learned Counsel for the petition. Mr. J. Bekul, Learned Government Advocate, has produced a gazette notification dated 9 September 2021, by which the deputy commissioners of the districts has been empowered to transfer grade 3 and grade 4 posts of all categories, including junior engineer and medical staff, from one place to another within the same district and same department, in consultation with the district head of the concerned department. Stop. He has also produced another order dated 1/8/2023, by which the Inspector of Schools, CTC Silchar, has released the petitioners from, has issued release order from the Office of the Inspector of Schools, CTC Silchar, to enable them to join to the new place of stuff.
Your Lordship may kindly record my submission that this has not been served on the petitioners, my lord, that release order.
Mr. M.K. Chowdhury, Leonard Senior Counsel, however, submits that the release order has not been served on the petitioner, and therefore we prays for some time to enable him to receive the instruction.
Monday.
Reach the matter again on Monday.
Monday.
14.
This status quo will continue, my till then.
Status quo order possibly to continue till the next.
Highly obliged.
Eight,
Problem of non-provincialization of petitioner service. My lord, some delay is there in coming to the court. But
How long?
no, my lord, it was, your lordship will kindly see, my lord, she was appointed in 95.
Before my learned senior friend start lordship, this music teacher case, there the appeal pending before this division bench lordship, whereby this entire provision has been challenged. In a similar case, lordship, remember lordship, another case lordship issued only notice and fix it after 4 weeks lordship, because the appeal is pending.
What is the problem here?
The music teacher provision case challenge regarding provisionalization.
Here, no, like it. Immediate teacher, they are
But
saying-
they challenged by it under division bench is under
But
challenge.
it is regarding qualification, I think, my lord. We have the qualification. The lordship will kindly see that order dated, my lord, page 26. Page 26. With reference to the subject cited above, I have the honor to furnish here with the following information as per records available so far as desired by the government by letter dated so and so. So the petitioner's name is also included. Next page, my lord. Serial number 82, page 27. Her and the qualification laid down is page 29. This is a relaxed provision. May I read this, my lord? Whereas representation from various teachers association and individuals in respect of music teachers have been received, that there was no prescribed qualification for the post of music teachers in venture higher secondary schools and high schools. And whereas the post of music teachers were filled up in provincialized higher secondary and high schools in the year 94, from amongst the candidates having minimum qualification of HSLC and Bisharat may be music from any recognized university boards, etc. And whereas the government is satisfied that the qualification prescribed for the post of music teachers in the provincialized high schools during the period 1/1/2006 may be taken into consideration account. Now, therefore, in exercise of the power conferred under section 14 of the 2011 Act, the qualification for the post of music teachers appointed in Venture High School and High School shall be HSLC passed and Bisharat Music BMUS from any recognized university board college. So we have the qualification. We have said, my lord, we have passed from a recognized university. So therefore, there is no bar for this to be considered by the secretary. Now the matter is pending before the secretary, and ultimately, my lord, headmaster of the school have page 34, my lord. Page 34. Page 34. He has also forwarded the matter to the inspector of schools. So let secretary consider the matter, my lord. And I have enclosed my certificate also. Huh?
That 2011 Act under which they have
That is crop. No.
already law the Punawati Kohama that
Even
Division
under
bench doesn't need
2017 Act provisions for music teacher is there.
as per the
Even
division
both under 2011 and 2017. What I am submitting, my lord, matter is delayed. This person, my lord, she is teaching music. Some my lord, students, they have also passed in music. So let secretary consider she is finishing her age also, man.
Secretary consider and pass the order.
Secretary cannot directly consider lordship because as per 17 Act, her name has to be recommended for the district scrutiny committee lordship.
We shall let it go to the scrutiny committee and decide.
But that will have to be, all the procedures will have to be followed.
Yes, we will follow it. We will follow the procedure.
But they have not filed the writ petition under section two, as per the 2011 Act, they have claimed as a relief
No,
lordship.
no, 2017 also, the provision of the music teacher is there. Whatever is required to be done, your lordship
And so far
may
the
say
music
so much.
teacher, that, Commissioner of the music, that has been under challenge in division bench lordship. It's
That
pending.
is regarding my lord
If the division bench
qualification.
goes against lordship, then there is no scope of consideration
But
lordship.
let it be considered by the
At this
scrutiny
stage,
committee
lordship-
now.
That
Okay,
cannot be-
then I'll issue notice
Yes,
for the
lordship,
time.
issue notice.
No, no,
lordship.
my lord, the scrutiny committee will consider,
Those are some procedures will have
Yes,
to be
lordship.
followed.
Right.
Some
Yes,
procedures will have to be.
approach earlier lordship in this.
So let us
lordship.
see what they come up with. I'll give you a short notice on.
Yes.
short notice, my lord, if necessary, my lord, will go to the scrutiny committee.
Yes.
Restatement number to the man.
মই এইটো পাহৰি গলো মই ওলাব লাগিব এইটো মই আইটেম চাইহে মনত পৰিলে কথাটো
But to restatement, there is no bar, my lord.
DT does. Then a senior counsel.
Number two,
assisted
Deepak.
by MS.
মই ওলাই দিম নহ'লে
Art Decker, then. Mr. SMT Chisti, then it's standing counsel, secondary education. Shall take instructions in the matter.
notice should go lordship
Let it come after 2-3 weeks.
2 weeks, my lord, let it be under.
no lordship there's no hurry lordship they should have approached this
Please.
earlier lordship now in 2020 they have approached and they want that
That's why I'm
secretary
saying,
should
that's why I'm.
consider
This the matter after 3 weeks.
We'll serve them the extra copies. Ma'am.
9.
May it please your lordships. My lord, petitioner is the in charge headmaster of Solmari High School lordships. And he was allowed to hold the charge on 2/5/2022 lordships. Lordships, during that period lordships, this respondent number 7 was under B.Ed deputation lordships. He has B.Ed, he was under B.Ed deputation. And lordships, on completion of his B.Ed deputation and passing B.Ed examination, then he approached before this honorable court, lordships. And this honorable court, lordship, page 29, lordships, disposed the matter where this petitioner, I was the respondent number 5, though my opportunity of hearing was not allowed, lordships. Lordships, page 29, lordships, passed the order, lordships, and in that order, lordship, the honorable court, page 32, lordship, page 32, that fourth paragraph, lordships, page 32, fourth paragraph, lordships. In the event of filing any such representation of the petitioner within the said stipulated period, the Director of Secondary Education, Assam, within a period of 30 days from the date of receipt of such representation of the petitioner, shall pass necessary order on the said representation, giving opportunity of hearing to the petitioner as well as the respondent number 5. Lordship, I was the respondent number 5 in that writ petition, lordships. And lordship, that subsequently, lordship, page 34, lordships. Page 34, this deputy director wrote a letter to the inspector of school, lordships. Inspector of school, NDC Nogao, second paragraph. In this regard, the Honorable Guwahati High Court passed an order on 13/3/23, directed the petitioner to submit a fresh representation before the Director of Secondary Education, Assam, through the Inspector of School, Nogao, on or before 13/3/23, lordships. And lordships, thereafter, lordships, this page 35, this letter, it was issued on 30/5/23. Lordships, Inspector of School wrote the letter
to the headmaster of Solmari High School, Lordships. Here it is, Lordships, with reference to the subject cited above, I am to inform you to submit the seniority list of teachers of Solmari High School in connection with WPC number so-and-so to the office of the undersigned within 30 days, within 3 days. Treat the matter as court urgent, Lordship. Lordship, when I received this letter, then only I could come to know. Now in these two letters, Lordships, letter dated 3/5/23 and 35/23, Lordship, does not spell out anything regarding I have to be given an opportunity of hearing. And I have approached before this honorable court, Lordships. Lordship, my qualification is BSc. I am in charge headmaster.
Opportunity of hearing will be given by the director, not by the inspector of schools.
These are just letter lordship written to.
This is just a
Interdepartmental letter.
communication
Yes,
on the
lordship.
direct, this court directed that the gradation list should be prepared.
Yes.
So they are saying to send the seniority list.
Lordships,
It's not a question of hearing you or not hearing you.
Lordships, if I am replaced by a regular headmaster, I do not have any grievances, Lordships.
That is in anticipation, he is lordship filing this.
But
petition, lordship.
But the thing is this, I should not be replaced by another headmaster in charge, Lordship.
How can he keep
Come
that,
to
lordship?
page 32.
Page 32, Lordships.
Yeah, fourth para, read it again.
The inspector of school, Nogau,
No. Fourth,
In
in
the
the
event of.
event of.
in the event of filing any such representation by the petitioner within the said stipulated period, the director of secondary education, Assam, within a period of 30 days from the date of receipt of such representation of the petitioner, shall pass necessary order on the said representation after giving opportunity of hearing to the petitioner as well as to the respondent. Number 5. During such determination, if DSC Assam comes to the conclusion that the petitioner possesses the requisite qualification eligibility to be a headmaster under the said 2018 rules, and the said respondent number 5 does not have such requisite eligibility, the DSC Assam shall do the needful in accordance with law, allowing such eligibility assistant teacher of said Solmari High School to be the headmaster of the said high school.
So where is the representation? He has not filed a representation yet, lordship.
No. The petitioner in that writ petition will
yeah.
have to come. He is the respondent number 5 in that writ petition.
5, Lordships.
So director has not taken any decision yet.
Lordship,
So
now,
when the director takes a decision, he is going to call the petitioner of the writ petition and you
Let's see.
and hear you. And consider whether you have the degree, whether the petitioner in that writ petition has the degree, and who's eligible. That decision will have to be taken by the director after giving an opportunity of hearing. But so far gradation list is concerned, there's no question of giving you any hearing. So there's nothing here in the writ petition. So far as gradation lists are there, what they are doing is they are following the directions passed by this court.
Yes.
They are trying to have the seniority list prepared.
but these two letters, Lordship,
What is this? What is wrong in these two letters?
Lordship, especially this page 34, Lordships,
Yeah.
letter dated 3/5/23, Lordships, issued by Deputy Director, does not say anything that the opportunity of hearing to the respondent number 5 to be given.
It doesn't arise, lordship.
Where, for what reason? It is for the director to take a decision after hearing you.
Lordship, now I have the apprehension that I am in charge headmaster, but I may be replaced by another in charge headmaster.
So you filed this on apprehension,
Yes. Only on apprehension, lordship.
then I'll have to dismiss your petition. You come when the cause of action arises. Till now, no cause of action has arisen.
Lordships, let notice be issued,
No,
Lordship.
I'm not issuing notice. You can withdraw and file afresh when the cause of action arises, or I'll dismiss this.
Withdraw lordships.
Withdraw.
Lords.
Our chairman will also propose. There's no withdrawal. With liberty to file a petition. Mr. Yasin, is still understanding also at best for the.
For the second education.
Petition is discussed and withdraw. Liberty is spread.
With liberty lordships. Right.
Then
May this lordship, lordship, the counsel for the petitioner is on legs, so may kindly pass over the matter for some time.
Item 10.
Item 10.
eleven,
Lorship, there was an advertisement by the respondent number 4 on 24 to 2022, and then again it was re-advertised on 23/2023 for the post of registrar of the University, Rabindranath Tagore University. Lordship will find the re-advertisement at page 16. This is the re-advertisement. Rabindranath Tagore University invites application from eligible Indian citizen for 4 numbers of administrative posts against unreserved category. The last date of receipt of filled-in application is 17/4/2023. Applications shall be received only in offline mode. The university will not be responsible for any postal delay. Now, Lordship, if your Lordship comes to page 17, clause 10, general condition and instructions. Instruction, general conditions and instruction, serial number 10, Lordship. This is the crux of the case, Lord. Persons in employment must submit their applications through proper channel with the following note of the employer in part C of the application form. The respondent number 5, private respondent number 5 has not complied with that general instructions. Now, Lordship, this is my application form at page 21, sorry. It starts from 21. And I have fulfilled the criteria, clause 10 of the general condition, Lordship, at page 37.
Yes.
At page 37, this is the clause 10 condition that I have fulfilled, Lordship.
Page 37.
Page 37, Lordship. That was issued by the employer, Lordship. Forwarding note of the employer, part C. Certified that Dr. Manjesh Shaikia has been employee of Rabindranath Tagore University since 25/3/1998 and at present working as associate professor. Information given by the employer is correct to the best of my knowledge. The organization has no objection to his or her candidature for the post of registrar at Rabindranath Tagore University. Now, Lordship, this is the impugned order issued by the respondent number 3, the Vice Chancellor, Lordship. At page 39. Lordship, got it.
Yes.
In pursuance to section 39(1) of Rabindranath Tagore University Act 2017.
Page 39.
Lordship.
Yes.
In pursuance to section 39(1) of Rabindranath Tagore University Act 2017 and the provision of the statute 4.2.1 of Rabindranath Tagore University, following selection committee is formed for selection of candidates for the post of registrar of Rabindranath Tagore University. Here there is the committee has been formed by 7 members, whereas requirement is 8. And 1 court, university court nominee should be there, Lordship. And here in this impugned order, university court nominee has not been nominated, Lordship.
Where's that from?
Lordship.
Where are we getting it?
This is the Gazette notification 4.2.1. And even I have stated in paragraph 7 of my petition also. 4.2.1, Lordship, mode of appointment.
Yes.
That court, university court nominee was not nominated, Lordship.
Mhm.
There should be 8, Lordship.
Then
Lordship.
yes.
Thereafter, Lordship, I filed an RTI application at page 41, but no reply has been furnished to me. No information was furnished to me. Reason behind this, Lordship, the private respondent number 5 is the blue-eyed boy of the respondent number 3, and he is bent upon to appoint him, Lordship, to the post of registrar. And the executive committee, after seeing this anomalous, Lordship, that imperial order, they have registered their I'm coming now. At page 12, they express their dissatisfaction regarding the constitution of the committee and the selection of that private respondent number 5. Now, Lordship, at any moment, Lordship, the private respondent number 5 may be appointed to the post of registrar. And this selection committee cannot exist, Lord. So the 4.2.8, Lordship, was violated, Lord. There should be 8, Lordship. So my respectful submission at this stage is that Lordship may issue notice and restraining the respondent number 3 to go ahead with the selection process, Lordship, of the respondent 5.
There are 4 posts, isn't it?
Lordship, there is 4 posts. I am for the post of registrar.
Where's the post?
Lordship. Page 18, Lordship. I am for the registrar. And there is a certificate issued by the in-charge registrar. Annex 1, page 15. This is my whole history of my appointment law. Page 15.
Yes, who appears?
Here I am appearing for respondent number 1 for university, Lordship. There is no concept.
Do they have a standing council?
I don't think so, Lordship. Earlier occasion also I
Notice
filed
me.
a petition.
That's correspondent number 1 I am appearing.
Heard Ada. Well, council for the petition. Issue notice. Mr.
A.R. Tawfiq.
A.R. Davildar, and the standing council, higher education. Appears for the respondent number 1. Petitioner to take steps for service of notice on the respondents 2, 3, 4, and 5 by registered post AD within 1 week from today. List the matter after 4 weeks. Stop. In the interim, comma. It is directed that the post of register of the
Rabindranath Tagore University.
Rabindranath Tagore University,
Pojai.
Pojai, which was advertised by advertisement dated
20/03/2023.
23/2023 shall not be filled up till the next week.
Deeply online.
Then
I'm sorry, but I could not understand when the matter was called for. Here, Lordship, the petitioner is aggrieved by the order of the district level committee, Lordship, that kindly, Lordship, come to, maybe please to come to page 28, Lordship. The last column, remarks column, page 28. This is the minutes of the district level committee. Petitioner's name is at serial number 7. That is second, Lordship, Nandan Jyoti Nath. And the last column, the reason is given not recommended due to want of requisite vacancy. Now, Lordship, the grievance of the petitioner is that, Lordship, this reason is not in terms of this 2015 notification, Lordship. because the clause 15 says if there is no vacancy in the parent department, in other administrative department, his case may be considered, Lordship. And that was not done. Secondly, Lordship, the reasons for rejection is also not issued by through a speaking order, which is a mandatory requirement of the office memorandum of clause 24D. So that is why petitioner is before Lordship. So Lordship,
When was the DLC held?
DLC Lordship held on page 10, Annexer 10, page 26, 12th of April 2018, Lordship.
And why are you coming so late now?
Lordship, I have explained because since I am not aware about the decision, Lordship, when I inquired about this, I came to know that my case has already been rejected, Lordship. And earlier in 19 or 20,
What's your
Lordship,
explanation?
in paragraph, Lordship, I have stated. Which is a mandatory requirement of this office memorandum, Lordship. In paragraph 6, Lordship, page 8. For a considerable period of time, the outcome of the DLC meeting on the application filed with the petitioner was not known to him, and the DLC Naga also not communicated the reason or outcome of its meeting to the petitioner. As per clause 24D of the WAM dated so, it prescribed that while disposing of the applications by way of rejection, clear speaking orders shall be recorded stating the reasons of rejection, and copy of such orders shall be furnished to the applicant, Lordship. That was not done, Lordship. But in the instant case, the neither such speaking order is passed nor furnish the reasons for rejection of the petitioner. After COVID period is over, Lordship, on being inquired, the petitioner came to know that his claim is rejected, and thereafter somehow he managed a copy of the minutes relevant portion, Lordship. So finding no alternative, Lordship, he approached all over. Although there is some delay, Lordship, but the same is not intentional and beyond his capacity, Lord. So, Lordship, at this, Lordship, the matter may be a press consideration, Lordship.
Yes.
Madam. Plus 15, madam. Otherwise, madam, there's a wrong on the part of the DLC, my lord, because petitioner has died on 2012 and application was made in 2017. But that part was not considered by the department, my lord.
No, even Lordship, if we go by the minutes of the DLC, Lordship, even 2011-10 matter was also considered.
But Mr. Dekal and the counsel for the petition. Who appears elementary, secondary?
I'm a bit
It's SMD Chief Field and Standing Council, secondary education.
one secondary eligibility post.
Appears for the respondent, 1,
1, 2, 3, 4, and 5.
2, 3, 4, and 5. And Mr. J. Bekul and Governor Advocate appears for the respondent number 6. Stop. Para. The father of the petitioner, let Misun Chandra Nath, while working as assistant teacher within bracket science at Srimanda Shangardev MS School under the Kapili Educational Block, Nagaon, died in harness on 9/2/2012. Stop. Thereafter, petitioner made an application on 16/10/2017 for appointment on compulsion grounds. Stop. The district level committee now considered the case of the petitioner in its meeting held on 12/4/2018,
18, Lord.
2018, and rejected the case of the petitioner on the ground that there was no requisite vacancy. Stop. But it is the case of the petitioner that the DLC, while considering the case of the petitioner, did not consider clause 15 of the office memorandum
1st of June
dated
2015.
1/6/2015 and
May I provide a copy of the waiver?
It's okay. And no speaking order was passed while disposing of the petitioner's application as prescribed under the
Clause 24D
as prescribed under clause 24 within brackets small
of the
d
said waiver.
of the OM dated 160.
Now, clause 15 says if sufficient vacancies are not available in the administrative department, then it is not.
Further, it is stated that the rejection of the petitioner by the DLC concerned was not communicated to the petitioner. And therefore, the petitioner was in the dark with regard to the outcome of his application. And it was only through some reliable source that he could get a copy of the BLC minutes recently stopped. But clause 15 of the OM dated 1/6/2015 prescribes that if sufficient vacancies are not available in any particular office to accommodate the persons in the waiting list for compassionate appointment, it is open to the administrative department office to take up the matter with other departments offices of the government to provide an early appointment on compassionate grounds to those in the waiting list. Stop. It appears that the DLC, while considering the case of the petitioner, did not take into account clause 15 of the OM dated 1/6/2015. Stop. Further, the said rejection of the petitioner was also not communicated to him on time. Stop. Accordingly, this petition is disposed of, directing the district level committee. What district was it?
District level committee to the deputy commissioner.
To reconsider the case of the petitioner afresh by taking into consideration clause 15 of the OM dated 1/6/2015 and thereafter pass appropriate orders in accordance with law. Stop. With the aforesaid observations and directions, with petition is disposed. Consider the case of the petitioner in its immediate next sitting, huh?
Within 2 months or 3 months.
In its immediate next sitting.
Lot.
Otherwise, if I give time frame, there'll be some problems.
Such, obviously. Deep level. 12. May I please? My lord, I take your lordship to page number 32, the seniority list, my lord. Petitioner is serial number 1, my lord, Smriti Hakolita, and the private respondent is serial number 3. Your lordship will find
Private respondent number?
respondent 4 is serial number 3, my lord. Your lordship will find the date of getting the graduate skills, column number 6 of the petitioner is 30/12/1983, and the private respondent is 17/3/1924. And my lord, your lordship will find in the column number 14 that the B.Ed degree procured by the respondent number 3 on 2020, and column number after 15 you also find on deputation. This is respondent number 3. By the date of getting the graduate scale, I am the senior, my lord, otherwise to her. Now I take your lordship to the deputation guideline, page number 41. Clause 2, below portion, page 41, clause 2. The deputation to undergo B.Ed training
shall be given only one time in the career. In case the teachers fail to pass the B.Ed examination in one attempt, he will not be considered for deputation for any more time. This is the deputation guideline, my lord. Your lordship will find at page 43 and exercise 6B. This private respondent in the year 1997 was given on page 43. My in the 1987, she has been granted deputation. She failed in that examination, my lord, B.Ed examination. And in the year 2020, again, she procured deputation, and thereafter, in this time, she has passed. Therefore, as per their guideline, it's not also it should be taken into consideration. What happened, my lord? They have issued the impugn order on 27/7/2023, whereby the private respondent has been allowed to hold the charge of the principal of the higher secondary school, my lord, Mongoldoi Town Girls Higher Secondary School, my lord. In the said order, my lord, they have stated that my degree, master degree, as was not with NOC. Therefore, my degree cannot be taken into consideration following the mandate of Rule 13 of the Assam Civil Service Conduct Rule 1965. In this regard, my lord, it is my humble submission that 1965 is a conduct rule. If an employee violates any of the conditions of the conduct rule, then there is a procedure for taking a disciplinary action against that person, my lord. It just because she some violation of any conditions in the service conduct rule cannot constitute someone degree is invalid or like that, my lord. It has if someone passes any degree without taking any NOC, suppose, then, my lord, that if that is taken to be a misconduct, then, my lord, has to be tried under discipline proceedings rules and 1964. That has not been done. Never they have issued any shock cause. Neither the disciplinary authority nor the controlling authority never issued any shock cause. In the year 2010, I have passed the degree, my lord. Now in the year 2023, all of a sudden they have debarring me on holding that my degree, because there was no NOC in the year 2010, I may not be allowed to hold the charge of the what called, my lord, the in-charge principal. This is a totally unjust and unfair state of affairs. Someone has to be found guilty as per the procedure of law.
But order is of 27/7/2023.
Yes, just 1 week back, my lord. Just 1 week back, it has been issued. Immediately thereafter, I filed this writ petition, my lord. Immediately thereafter, she has got 22nd August. I have filed, my lord. Immediately thereafter, it was served on 31st July by the department, and I have collected the copy and filed on 22nd, my lord. Immediately.
And order came into the force with FR 1/8/2023 already came into force. Issue notice because the allegation
there cannot be more earlier than this time. This is appropriately, sir, I have filed, my lord, in time.
It came into force with effect from 1/8/2023.
Whatever, my lord, it has to be suspended for time being.
And it's hurt Mr. D. Purkayastal and council. Will issue notice? Issue notice.
And for time being, it will be suspended, my lord.
Oh,
Or my lord, your lordship will direct the director to give the charge of the school from the to the inspector of schools, my lord.
Stop. Issue notice. SMTG still and standing council.
123.
Blatant irregularities are there, my lord.
Secondary education appears for respondents 120. Petitioner to take steps for several notice on respond number 4 by registered post AD within 1 year. In the entry, the order dated 27/7/2020, by which the respond number 4 has been allowed to hold the charge of principal of
My lord, may issue
Mongoldoi, Mongoldoi Town Girls High School.
Mongolai Town Girls Higher Secondary School. District around.
Obliged, Lordship.
But if the respondent was joined lordship by this time, lordship. The respondent for may join lordship in this time.
That we will have to suspend.
Obliged.
13.
My lord, this is the fourth time the petitioner has approached this honorable court. And the fact of the case goes like this, that in the year 1998, an advertisement of LDA post was there. And although the petitioner was of the top of the list, another person was appointed. Therefore, I filed one writ petition in the year 1999. The order is at Annexure 1, page 20. First writ petition, where a direction was given to consider the matter of the petitioner within a period of 1 month. Page 20, and relevant portion is at page 24. That's from last portion of page 23. Within 1 month. My lord, it was not done. Therefore, the petitioner again filed another writ petition in the year 2005. And the second order is at Annexure 3, page 27, if my lord may peruse. And in this writ petition also, that the respondents' authorities were directed to give the proper consideration to the petitioner. And there is, at the last portion, the relief was also given if the petitioner feels aggrieved by the decision which may be reached by the respondent, he shall be at liberty to approach this court for appropriate relief. Now, thereafter, my lord, all the at least 10-20 pages, Annexure 4 to Annexure 8, so many communications were there between the department authorities from director, commissioner, inspector of school, but no relief was given. However, it is an interesting point at page number 34, Annexure 6, if my lord may kind enough to peruse. It is the report of the inspector of school. Page 34. It is very crucial, my lord. And as per this report of 2007, the inspector of school clearly says at point number 2 and 3 and 4. Point number 2 says that the initial person who was appointed as LDA, Subut Kalita, was not within the first, second, and third of that select list. There is no signature of the chairman of that select list. Point number 3 says that another select list was there with proper signature of the selection committee, where I was the top of the list. And point number 4 says that there was a recommendation from the minister recommending the name of that person, another person. Now here, my lord, another fact is that in the year 1998, soon after the appointment as LDA, that person, Subut Kalita, was upgraded to assistant teacher. So since 1998, that LDA again remained vacant. And thereafter, my lord, instead of giving me that effect, the department went ahead with fresh advertisement. Therefore, I filed another writ petition. And the order is at page number 67. Relevant page is 67 and starts from 57. Sorry, Annexure 12, 57. It is the affidavit filed by the department, and the order is at, my lord, Annexure 14, page 67, sorry. This is a detailed order passed by the Honorable Single Bench, where it covers all the aspects. And the relevant portion is at page number 77, my lord. There were 3 directions, page number 77, my lord, may I please. This judgment was passed in the year 2019, 4th of October 2019. And the relevant portion is at page number 77. There were 3 directions. First direction is that consider the case of the petitioner within 1 month. This is the first direction. Second direction is that as because of this laches and negligence done by the department, an amount of rupees 1,50,000 was cast upon the respondents as fine. That is also to be paid within 1 month. However, a review petition is there against that fine amount pending before the single bench review petition. But third direction was there to consider and look after the negligence as well as the wrong in connection with that appointment of that person, so would call it. However, I am not challenging whatever has to be done to him. I am for myself only. And after this direction, my lord, a order has, I have filed one contempt case in the year 2020. Although there was a specific period, but in the year 2023, recently, 23rd of June, Annexure 15, page 79, the order has been passed. Impugned order. This is the impugned order passed by the secretary. And it says there, at that initial period, when selection process was going on, there were some correction in my written test copy. Therefore, my claim was rejected. After so many years, in the year 2023, they have been saying that some correction was there in my copy, written test copy. Therefore, my claim was rejected. Whereas in the year 2017, the inspector of school specifically states, and that does not say anything about. And the custody of those documents all these years with the respondents. My lord, relevant portion is there. Order is at page 80. This is the fourth times I have been before this honorable court.
Yes.
Well, here regarding the Sandan Kolita, the petitioner, here is apparently it was, my lord, manipulation of some marks. So here page was
DK Nath.
DK Nath, the not concept of
Nath, NATH.
issue notice. Mr. U. Sharma, the understanding concept.
for respondent number 1, 2, and 3.
Secondary resolution appears for response 1, 2, and 3. Petitioner to text that for service of notice on response number 4 by registered proceeding within 1 week from the list of matter.
My lord, may I pray for interim order not to go with the fresh advertisement, because if fresh advertisement,
There are some lot of discrepancies.
my lord, but after so many days, years, they've been coming with up now. Yeah. And may I pray for another thing, that record, they are saying, such alleging, that may be called, because earlier time also.
Let the notice go first.
Yes. Okay.
No, no, please. Please, Dr. 2 weeks.
15.
This matter may be taken up on any hearing, the lordship, as agreed by my friend also.
Next week, my lord.
On request made by the parties. It's the matter of 17th.
17.
Lordship,
17 I have some problem, my lord, so
22nd, lord, can it be on 22nd?
24th, my lord. 24th.
20.
Anyway.
16.
May I please, as your lordship? Lord, in fact, in this petition, my lord, we have challenged the certain notices which had been issued by the District Development Commissioner of, my lord, the then Sonitpur district, my lord. My lord, the ground which we have taken, that the memorandum in the nature of an allegation had been lodged against the present petitioner, who is now working as the, my lord, in charge principal, regarding, my lord, the provincialization of the services of the staff of the said college, along with some other allegations, my lord. A similar sort of allegation had also been leveled again before the office of the Director of Higher Education, my lord, as well as in the police. Now, my lord, what has happened? The three parallel proceeding for the same set of allegations is continuing. And that apart, my lord, what the authority has done, that is the District Development Commissioner, has sought for, my lord, certain documents from me, which is not permissible, my lord, in terms of the provision which I have relied in my petition, my lord. And my lord, the District Development Commissioner, if my lord may be pleased to find, this honorable court, my lord, while passed an interim order, my lord, stayed the proceeding against me, has held, my lord, that the subject of provincialization, my lord, has already been taken care of by the 2017 Act, my lord. If somebody's provincialization had been done wrongly, then, my lord, that can be a review exercise can be done in terms of the provision of section 17 of the, my lord, say 2017 Act. So therefore, this, my lord, proceeding which had been instituted is, my lord, without the jurisdiction, and therefore it has been stayed, my lord. Now, my lord, the issue, what has happened during the pendency of the petition, my lord, a certain development has taken place. The allegation which has been brought that one Jutika Das, my lord, whose provincialization, my lord, was done by virtue of some of the anomalies, in which anomalies I, as a principal, my lord, was involved. This Jutika Das has already, my lord, gone from this college, my lord, and has opted for the service in some other colleges, my lord. Now, in such a situation, my lord, whether these said allegations subsist or not, my lord, my lordship may be pleased to consider that aspect also. But those things, my lord, I have not brought on record till date, my lord. And on the other hand, my lord, the District Development Commissioner has also filed an affidavit. My lord, in that affidavit, they tried to substantiate and tried to justify the proceeding initiated against me, my lord, that that Jutika Das, my lord, was working in some other college. Now, how her services can be provincialized at the same, my lord, in my college, my lord. So these are the things, my lord, they have said in their affidavit in opposition, my lord. So, my lord, if my lord allows me, my lord, I will bring the regarding the leaving of that Jutika Das from my college and joining in some other college on record, my lord. That will, my lord,
Additional affidavit.
by filing an additional affidavit or in the nature of a, my lord.
Yeah, beyond the council for. It's allowed. How much time you require?
My lord, 2 weeks.
2 weeks time
My lord.
to file an additional. List the matter after.
My lord. Obliged, my lord.
17.
Please, your lordship.
Lordship, we have filed this petition on behalf of mother. The petitioner's son died while he was in service.
Petitioner's son
Died while he was a dependent to his son. And he had a wife who is respondent number 7 in this case. On the last occasion, my lord, the respondents wanted to file the affidavit, but as I have been informed by the standing counsel that they will not file affidavit today.
Who is the standing counsel? Elementary.
Elementary.
Elementary has not filed affidavit, my lord.
That's why the petitioner's counsel is saying that they are not filing.
Otherwise, my lord, as per an amended, my lord, that pension part can be apportioned, my lord, between the petition and part. Amended, my lord.
No, who appears for elementary? Are you filing affidavit or not?
But on last occasion, he sent one was appeared.
Exactly, but you have,
My lord, she informed me that she will not file affidavit.
okay. Where's Fukan?
I'll call it. Call him.
Call her.
Can we pass over a timing, my lord?
Yeah, pass over for a second.
18.
Wait, please, your lordship. My lord, I petitioner before lordship challenging the termination order, my lord, by the school managing committee, my lord. Please may you kindly see page 30 annexure E, my lord. This termination order was passed by giving some, my lord, stigma, my lord, against that, my lord. Please may kindly see, may I read, my lord. This order has been passed on 12/8/2015, my lord. Termination from the post of contextual additional mathematics teacher. It is humbly hereby inform you that, may, my lord, lordship got it, page 30, my lord. Page 30, my lord.
Yes.
Yes, may I read, my lord.
Oh.
It is hereby inform you that with reference to the subject cited above and pursuant to the letter dated so-and-so issued by the Inspector of School Nagaon, as per decision taken in the urgent meeting of the School Management Development Committee of Sri Pitambor Devagoswami High School, Moharni, Nagaon, held on 11/8/2015, you are released, terminated from service as contextual additional mathematics teacher with effect from 10/8/2015. As per terms and condition number 9 of the agreement, your appointment, and since your conduct has put a black spot, very important, my lord. Since your conduct has put a black spot in the prestige, reputation, and educational environment of the school, and considering the fact of not to cause any future harm in the educational environment of the school, and since the news of your illegal conduct has published in the media, and you were arrested by the police in the said offense, the School Management and Development Committee has taken this punitive action against you, my lord. My lord, in this order, in this, my lord, order, termination order, what happened, my lord? One FIR was lost on 9/8/2015, and petitioner was arrested on 10/8. FIR was lost on 9/8/2015, my lord, 9/8/2015, and arrested on judicial, arrested on 10/8/2015 by the, and after 2 days, and termination order was passed on 12/8/2015 after 2 days, my lord. My lord, my
humble submission before lordships. Within my lord, in judicial custody within 2 days, without notice, without any show cause, I was terminated. On the other hand, this is a contextual appointment, no problem. But if there is a stigmatic view in this particular termination order, my lord, the authority cannot terminate me without departmental proceeding. This is the main contrast of my writ petition, main issue of the writ petition, my lord. Before that, my lord, your lordship, go to page 23, my lord. Page 23, my lord. Initially, my lord, I was a mathematics, my lord, completing master in BSc in mathematics, and I was initially appointment in the said school, my lord, as a my lord computer teacher, my lord, and thereafter, my lord, page 24, my lord. Page 24, my lord. One advertisement was issued on 2010 by the school managing committee, and thereafter he was elected. 12 candidates appeared, and I was selected, and I was appointment. Page 24, my lord. The T.D.F. Sharma, son of so-and-so, has been engaged to the act as an assistant teacher, general mathematics on contextual basis for a period of 30 March 2011 for the date of joining, 14 August 2008, subject to the execution of terms and contract enclosed herewith, my lord. And thereafter, my lord, the secretary to the government of Assam Education Department, page 25, my lord. The all contextual appointment appointed by the school management committee, my lord, and they have, my lord, please may kindly see, in partial modification of the department earlier notification dated 10/6/2010, the governor of Assam is pleased to increase the remuneration of additional teacher on contextual basis 15,500 per month. So further, engagement of contextual teacher will be a period of 12 months instead of 11 months with effect from and with immediate effect until further orders. However, the contextual teacher will require to be 1 hour special class during the summer vacation, my lord. And thereafter, my lord, what happened, my lord? Next, page 27, my lord, no, sorry, 27, Annexure C, 28, my lord. This is the bail order, my lord. One FIR was lost. Please kindly see the bail order, my lord. This bail order was passed by the additional session and district judge 9/11/2015, my lord. Seen the petition so-and-so filed by so-and-so, T.D.F. Sharma, who has been detained custody since 10/8/2015, my lord. I was arrested on 10/8/2015, and FIR was lost 9/8/2015. And please make a learner, so the victim is a advocate for the petition. Victim is a major girl, aged about so-and-so, detention, and I was released on bail, my lord. After release on bail on 9/8/2015, I was received this letter of the termination, that I was terminated without show cause, without notice, without giving any opportunity hearing. They terminated me. Now, my lord, thereafter what happened, my lord? I filed a writ petition before the honorable court, my lord, earlier on against that, my lord. Page 33, my lord. The honorable court, my lord, may I read, my lord, and there, honorable court, having last paragraph, my lord, page 34, my lord. Having regard to the limited pair made by the DDAS, it is not considered necessary to issue notice to the respondent for, and writ petition is disposed of at the motion stage itself without expression any opinion giving liberty petition to file representation before the so-and-so. In the event of any such representation be filed by the petitioner, same shall be disposed of by the Director of Secondary Education within a period of 2 months, if necessary, by hearing petitioner and member secretary school managing development so-and-so, and writ petition stand disposed of. In the meantime, I file a representation before the director, my lord. Director pass an order, which also challenged before lordship, page 36, my lord.
Seen the Honorable High Court order at so and so pursuant to the selection Tdip Sharma. Pursuant to the selection, Tdip Sharma was engaged as additional teacher contextual mathematics in so and so this on 14/8/2010. On 12/8/2015, SMDC of the school terminated Tdip Sharma from service while he was in custody. Following his arrest under section so and so, peruse the representation so and so. Next, on 10/5/2006, Jivan Chandra Bora, headmaster of Sri Pitambardev Goswami High School, is still under after the untoward incident that had happened with the student. The headmaster stated further that there is every possibility of the boycott. Main issue is that every possibility is a presumption that the possibility of boycotting the school by the students of if Tdip Sharma is reinstated. Only because of this says that apprehension that school student may boycott. I am convinced with the statement that Headmaster Tdip Sharma so and so like so plurality and reinstatement of the TD Sharma in service will deteriorate the academic atmosphere so and so. On the basis of that, the director disposed of this writ petition. This is the without any order, only on the presumption that student may boycott the if I am reinstated, so thereby no any order has been passed, my lord, and which are challenged before lordship. And thereafter, my lord, my case was I was acquitted by the special judge Nagaon, my lord, page 39, my lord. And immediately, my lord, after acquitting my case, my lord, I filed a representation, page 45, my lord. Deputy Commissioner, School Management Committee, school inspector, and they did not reinstate me. Now, my lord, my contention is that, my lord, whether a contextual service can be terminated by giving, my lord, punitive, my lord, by putting a stigma. They can terminate it without so-called notice or without any opportunity hearing by them. This is my contention of this writ petition, my lord. And in this, my lord, termination, they also stated that there is a agreement, my lord. Agreement stated that they say that
Where is the agreement?
the agreement is not in my hand, but I am stated in my paragraph, my lord. Just a minute. Just a minute. Page para 22, page 17, my lord. Para 22, my lord. That the petitioner begged to state that clause 9 of the agreement executed by the petitioner and other at the time of engagement of the contextual basis provides that service of the contextual employee can be terminated in case of found to be guilty of any insubordination, interference, or other misconduct of any breach of non-performance. In the instant case, the competent court acquitted the petitioner from charges in the criminal case, and SMDC had neither initiated any proceeding against the petitioner to prove the allegation, and the allegation level against the petitioner had not proved by any authority, including the SMDC, and therefore the ground of termination of service on the basis of 9 clause agreement executed petition not sustainable. This is my lord submission, my lord. And regarding that issue is concerned in contextual employee, whether contextual employee is necessary to issue any show cause or not. Regarding that issue, my lord, your lordship, there is a judgment of this honorable court, my lord. The similar issue was raised before this honorable court. Honorable court pass an order. Please may kindly see, my lord. 2018 1 GLT page 40, Middle Decca versus Union of India. This service law termination of service contextual appointee petitioner appointed as data entry operator on contract basis on 21/9/2012, and his appointment renewed from time to time, and last renewal made for 3 years with effect from 1/1/2015. Petitioner terminated from service on the ground he was found guilty of misconduct and misbehavior. Therefore, my lord, reading my lord, main quotation I am reading. May I read, my lord? Para 16, my lord. Para 16, my lord. Marriage. Para 16. I have considered submission advanced by the learned counsel for the parties and perused the material available on record. As can be seen, the petitioner is a contract appointee under the respondent organization whose appointment was renewed from time to time and from the office order dated 31/12/2014. His appointment is to substitute only up to so and so. In terms of the said office order, a cautionary note under the given facts and circumstances was to be issued against the petitioner for his conduct, and a copy of advice displeasure note to be endorsed to the establishment division of records appropriate action. Although the learned counsel for the respondent number 2 and 3 submits that office memo number so and so is cautionary note given to the petitioner, but however on perusal of the same, it cannot be said it is a cautionary note, but in fact notice calling explanation for the petitioner within a time frame of 2 days. Against the office memo, the petitioner submitted explanation so and so whereby explained the reason for his outburst, at the same time ought an apology for his behavior before the respondent number 3. If the office memo is to be presumed to be a cautionary note, the matter would have ended there. However, by the impugn order, the impugn order 22/6/2015, the respondent number 2 purportedly acting upon the report submitted in respondent number 3 terminated the service of the petitioner. Besides mentioning the report submitted by the respondent number 3, impugn order termination also provides that petitioner was found to have committed misconduct and misbehavior. Therefore, he violated the terms and conditions of the contract. Thus, from a perusal of the impugn order dated so and so, it is only appeared to be stigmatic as the satisfaction of the authority who terminated the service of the petitioner that petitioner was indeed guilty of the charge and allegation is apparent. Such finding of conclusion without due process or without affording opportunity to the petitioner, even a contextual appointment would only be arbitrary and unjust. Therefore, impugn order of termination, considering the authority relief upon the learned counsel of the petitioner, more particularly managing director so and so, is found to be unsustainable and warrants of interference. Having opined so, dwelling upon the other authorities relied upon the learned counsel for the petitioner would be to be required. As for the contention of the learned counsel appearing for the respondent on the question alternative remedy available to petitioner, I am the considered opinion that in the given facts and circumstances of this jurisdiction of the court, under 226 of the Constitution of India, cannot be said to be outstayed, and moreover, it may be noticed that respondent have not raised issue either in writ appeal, they have preferred nor during sure affidavit in opposition. As may be noticed, the writ petition was filed so and so. Therefore, I am inclined to reject the so account of availability of remedy. In view of the above impugn orders are hereby set aside and quash, petitioner shall be reinstated forthwith by giving 50% back wages. And regarding this issue, my lord, another, if honorable court permit, the other judgments are also there, my lord. If there is a termination is stigmatic, then you have to follow the due process of law. In my case, I was arrested within 3 days. After I am behind the bar, without affording opportunity, they have given the by giving the.
Where is the agreement?
But the agreement is not there, but agreement regarding that I am by. There is no, that
have a-
doesn't say
You
only,
have
my
a
lord.
copy of the agreement?
If found guilty, my lord, if found guilty, my lord, that agreement, I was not, my lord.
No, he was initially appointed by the school managing committee on contextual basis. So, and school management committee has terminated, and the director has no role on this part, my lord. And moreover, director passed the order on 31st May 2016 upon the basis of hearing, and it is found that there is.
Headmaster could take it.
Yes.
Who appears for the school?
My lord, is school in services concerned, my lord, so many times are going thereafter, my lord. Honorable court man pass an order directing give the copy to the inspector of school, and by giving justice, inspector will go to give the principal. And on the basis of that, school inspector is there is a order, my lord, by the Honorable Justice A.M. Bujarbura, my lord. And we have taken steps in spite of receiving the notice, they did not come, my lord. Order dated 4/9/2021. 4/9/2021. And accordingly, we file an affidavit, my lord. And pursuant my affidavit, the service was completed, my lord. As per the office note, my lord.
So till that none appears.
Till the day they are not interested, man. I have given so many times, and thereafter inspector also given personally, but they are not interested, man.
No, where's the copy of the, do you have a copy of the agreement?
Copy of the agreement is not there, my lord.
You'll have, obviously you'll have.
No, we have not. I am very much, and I am seeing the net, my lord, regarding clause 9, my lord. That is say thereby I am submission was statement was given, my lord.
No, but you'll have a copy of the agreement. You signed the agreement. Deed.
No, man, I have not. They not.
You
provide.
check up with your petitioner.
No, my lord. There's no provide any agreement, my lord.
How can you say there's no agreement in your hand? You'll have a copy of the agreement.
My lord, as per instruction says that clause 9.
That's what I know.
Oh, my.
Where's the copy of the agreement? Unless the school comes.
My lord, to settle the matter, they may prefer for a tribunal also.
No, this is not case, my lord. This is a specific, there is stigmatic view. How can you, there is they have the power under 226.
No, it's not only private school.
No, this is a government school. So, no. And thereafter, similar situated persons already regularized, there is a order, my lord. All of the Assam, they are regularized, my lord. Already annexed, my lord.
My lord, the managing committee has no role to appoint. They have no power.
No, Mr. Council.
In the Jahangir case also,
No. Initially, all appointment is there. You read the file.
You have not filed your affidavit. You are not.
Yeah.
My lord, their basic allegation against the FMDC.
Page 50, my lord. Page 50.
50.
Yes, my lord. Given the there's a notification issued by the government of Assam, Director of Secondary Education, my lord. In reference to the subject, I have the honor to inform the government of Assam pleased to issue notification under the matter providing equivalent benefit or regular pay scale to the corresponding service benefit working additional teacher engage a contextual basis in different high secondary school and high school madrasa under same standing and improve quality of the secondary education state of Assam as per notification so and so between same as all over Assam, same appointment, my lord, all are my lord regularized. I was my lord terminated at the moment when I am behind the bar, my lord. So my lord,
In the next.
our main issue is concerned is whether this termination order is given the stigmatic or not. This is the main issue. The termination order, please may kindly see page 30, my lord. There is specifically there is a stigmatic view, and Honorable Supreme Court as well as Honorable High Court also, my lord, other judgment
Only
also.
issue is I want to see the agreement. that's all.
Agreement, my lord, I have seen.
Obviously, you will have a copy of the agreement. You signed the agreement.
My lord, matter will be taken up further on Friday. On Tuesday, my lord, I will produce. I will manage how can I.
Okay.
With this. Matter will be taken up further.
In the meantime, I will take instruction, my lord.
My lord, taken as a further, my lord.
So if it's part, it will be difficult on Tuesday.
My lord, already hard, my lord, your lordship.
Hurt, Mr.
Niran Bora, my lord, and Bora.
And Varal and counsel for the petitioner. Also hurt Mr.
You, Sharma,
and
for
Mr.
secondary.
Secondary. Mr. N. Varal and the counsel for the petitioner shall produce a copy of the agreement signed by the petitioner. With the
With the my lord, SMDC, my lord.
with the SMDT of Sri Pitambar Dev Goswami High School, Burhani, at the time of his offer. Please the matter again on
Tuesday, my lord.
Tuesday is Independence Day.
Oh, sorry. Thursday, my lord. Next Thursday.
You want it on 17th?
Yes, my lord.
17th.
As a my lord, pardon, my lord.
Parted will be.
My lord, my lord.
Parted will be, I will not be. This
My-
court may not be.
My
sitting
lord,
on
my lord.
17th. You want it parted?
I want to, because of I will be a hard, your lordship is the hard, my lord. So, my lord, your lordship have the part.
Okay, if you want it early, we'll fix it on 17th without, not just parted.
My lord, 7.
19.
My lord.
Made, please, your lordship, by this application, I have challenged the impugned letter issued by the deputy commissioner, and subsequently that was communicated by the inspector of schools, whereby interfered in the selection process of the junior assistant. Madam.
Yes, Shama, you have the records?
Yes, earlier occasion, my dear lordship has.
Yes, matter, my lord. Yeah, my lord. A letter received from the inspector of school. Here it is stated that, sir, while the matter was knocking at the door of Honorable Court, the existing principal IC of the school was asked to submit the relevant documents relating to the said selection test, but the principal IC of the school expressed his inability hide this letter number so and so, dated so and so, day of July 2023, to submit the same, as no such documents have been received by him from the predecessor. However, sir, some other documents relating to the said selection test, such as paper cutting of the advertisement, Annexure B, record marks secured by the candidates, and a report submit of this office by letter number GDC so and so, are available with the office of the inspector.
Where are the records?
But the reports are, IC principal is not able to hand over us. Earlier headmaster has not hand over to him, my lord. So he is not able to hand over us. This is the letter.
I don't need to see the letter.
Otherwise, my lord, the deputy commissioner has no jurisdiction as per the statutory law is concerned. My lord. Already I have earlier placed before your lordship that the as per 2003 rules, my lord. Rules poll is very clear. Deputy Commissioner has no role at all, and pursuant to that similar facts and circumstances, this Honorable Court has passed judgment, my lord. I have a judgment that has been reported, my lord. Out of the same facts and circumstances, Deputy Commissioner in the midst of the selection process interfere into the process, and then they approach before this Honorable Court, and this Honorable Court, after detailed discussion, held that the Deputy Commissioner has no authority to interfere to the selection process in the junior assistant of the high school and higher secondary school.
Yes, proceed.
Well, what had happened, the pursuant to the advertisement dated 30/10/2019, madam,
Page,
page 33.
yes.
Advertisement was issued for filling up the post of junior assistant, madam. And pursuant to this advertisement, the present petitioner along with others applied for, and accordingly, the admit card was issued on 26/2/2020 for written examination, which scheduled to be held on 8/3/2020. And accordingly, 8/3/2020, the written test was held and the result was declared on the same day. But kindly page 43, minute. And the petitioner stood first. This is the list of top 10 candidates of written test for junior assistant Krishnai Madrasa SS School. The name of the petitioner at the top, Malad, Muhammad Nadim. Then thereafter, due to the COVID-19, the computer test as well as the viva voce test was not taken place. And after that, the inspector of schools issued a letter on 2/9/2020, directed the principal of the school concerned, which is at page 45. This is the letter issued to the principal to proceed with the computer test as well as the viva voce test. And accordingly, the calling letter was issued on 19/10/2020, which was handed over to the petitioner on 27/10/2020.
On
And on 27/10/2020,
page,
page 48. This is the calling letter issued to the petitioner. And the schedule of the computer examination as well as the viva voce test supposed to be held on 31st October 2020. But on the next day, that is on 30/10/2020, the impun notice has been issued, which is at page 51. No, page 49, sorry. Page 49. 49, the notice has been issued by the principal that it is hereby notified to all concerned that due to unavoidable circumstances, the computer and oral interview for the post of LD at Krishnai Madrasa SS School to be held on 31st October 2020 is postponed until further order. After this notice, my lord, the petitioner inquired about the matter, and then it has come to knowledge that on 28 October 2020, which is at page 51, my lord, a letter has been issued by the Additional Deputy Commissioner Gwalpara to the Inspector of Schools by saying that, with reference to the subject cited above, I am directed to request you to stop all kinds of appointment and posting related activity pending in Krishnai Madrasa Higher Secondary School, Gwalpara, with immediate effect. And pursuant to this letter, my lord, the Inspector of Schools, which is at page 53, issued a letter to the principal of Krishnai Madrasa SS School. He wrote to the letter to the principal by saying that all kinds of appointment in respect of the junior assistant is to be stopped until further order. And then, my lord, what had happened in the meanwhile, suddenly the one executive magistrate went to the school of Krishna Higher Secondary School and suddenly called the petitioner to appear in the chamber of the principal of this school, and he went there and give him a question paper which was wrote in 7 months ago, and he confused and he could not answer properly all the questions since he has wrote in 7 months ago, and subsequently came to know that on the basis of a complaint, a inquiry was conducted, and this is a part of inquiry. Suddenly asked the petitioner to come and give him a question paper and return him, and he got lesser marks. Then the deputy commissioner has submitted a report, which they have filed the affidavit in opposition, running page number 58,
Respondent number?
Respondent number 3, running page 58, And the report is at page 61, running page 61.
Yes.
This is the report submitted by the assistant commissioner cum executive magistrate, the fourth paragraph, a field inspection was performed. Lordship got it.
Yeah.
A field inspection was performed on 27/10/2020 at Krishnai Madrasa SS School. Mohammad Nadim was called to the spot. He was asked to write the same question paper that he wrote on 8/3/2020. His score was only 16.5 out of 80 on 27/10/2020. Observation: as the candidate Mohammad Nadim got only 16.5 marks out of 80, his score in the main test is 70, is very doubtful. Although the test was conducted on the same question paper after 7 months, his excessive low score is so and so, is not acceptable. There may be illegal ways employed for his exceptionally high score in the written test, as there were neither any syllabus specified in the advertisement nor the question paper was easy. As there is a huge difference in between the Nadim's obtained score so and so on 2 different dates, a definite doubt arises regarding his exceptional high score in written test held on 8/3/2020. Mohammad Nadim's qualification is BA with 44% score. The undersigned is of the view that benefit of doubt should not be given to the Mohammad Nadim. A retest should be conducted under supervision of the Honorable Deputy Commissioner Gwalpara. Written test should be conducted in a place outside Krishna, preferably in Gwalpara, and question paper should be sent under the supervision of the Deputy Commissioner. And in counter, my lord, the Inspector of Schools also filed affidavit in opposition, which is at running page number 74, my lord. And the relevant portion is at page 77, my lord. The respondent number 5. Yes. Paragraph 8, my lord, start from paragraph 8, that the deponent humbly begs to state that as per the order of the District Development Commission, by order dated 4/2/2020, Srimati Kobita Deka ACS, the Assistant Commissioner Gwalpara, and as per order of Additional Deputy Commissioner by order number so-and-so dated 6/3/2020, Sri so-and-so, the election officer Gwalpara were engaged as supervising officer for the said selection process. That is this selection process. That the deponent humbly begs to state that the then Inspector of Schools, GDC Gwalpara, dated 7/3/2020, requested the supervising officer to supervise the written test and randomize the question paper for smooth conduct of the selection process. The sealed question papers and answer keys were kept in the Treasury Office, Gwalpara, with a letter to the Treasury Office dated 7/3/2020. Accordingly, the selection process for the post of junior assistant of Krishnai Madrasa SS School was completed. The selection committee submitted the list of top 10 candidates of written test held on 8/3/2020. Mala, the relevant is at next page, Mala, 11 paragraph, that the deponent humbly begs to state that in the meantime, the aggrieved candidates have filed complaint petition against the written test of LDA Junior Assistant Krishnai Madrasa SS School, and so the then Inspector of School GDC Gwalpara Bhait letter dated 9/10/2020 directed the principal cum member secretary of the selection committee of Krishnai Madrasa SS School to submit a detailed report on the complaint. Accordingly, a detailed report dated 20/10/2020 was submitted by the principal of Krishnai Madrasa SS School, stating that written test was done smoothly under the vigilance of the supervising officer and the inspector of school GDC Gwalpara. There is no such anomalies happened in the written test. On the basis of presumption, my lord, this report has been prepared. And now, my lord, I like to draw your attention in the rule 2003 rules, my lord. New books, education.
H,
Yes, this one.
H,
Page, my lord, 372. Rule 4, my lord. 368, my lord. The method of recruitment, my lord. Recruitment to the cadre of lawyer division assistant under rule 32A2 and class 4 post under rule 32B in the office of the higher secondary and multi-purpose school shall be made directly by the appointing authority from the select list prepared by the school selection committee constituted under the provision of rule 8C on the basis of the test and interview. The principal and headmaster, as the case may be, where the vacancy exists likely to exit within the next 3 months, shall submit the proposal for filling up the so-and-so. The relevant.
where's the constitution of the selection committee?
Constitution is at page 372, minute. (372) substituted rule 8, bottom. Here is the chairman is the president of the managing committee, and member 1 teacher to be nominated by the managing committee, 1 parent to be nominated by the managing committee, the principal and headmaster of the school, that is the secretary of the managing committee. This is the selection committee.
Where's that?
Well, 8.4.
8.4.
No, 8.1, just bottom, rule 8, 372 page. Recruitment to the post of teachers, minute. Bottom, minute.
Yes.
So deputy commissioner has no role at all, minute. The selection committee is sent to the inspector of schools, and then inspector of schools issued the appropriate appointment order, minute. But in the judgment, minute, also clearly is judgment, minute, 2017 to GLJ, minute. And at page 453, para 8, my lord, relevant. From para 8. My lord, got it? The post of LDA, which has now been redesignated as junior assistant, included class 3 of the Assam Secondary Education Provincial Service, defined rule 2S of the Assam Secondary Educational Provincial Service Rule 2003, read with rule 32A, small a, of the rule. Rule 4 of the 2003 rules lays down the method of recruitment to the post of junior assistant, which says that the said post shall be filled up by way of direct recruitment by the appointing authority from the select list prepared by the school selection committee on the basis of the test and interview. As per Rule 4, Roman 4, the school selection committee shall prepare a select list of candidates containing double the number of the vacancies, and the member secretary shall submit the select list to the appointing authority for appointment. As per Rule 2B, Roman 2, Inspector of Schools is the appointing authority for the post of junior assistant. The appointing authority shall fill up the vacancy in order of merit by following the reservation of principal from the select list. Next one, as per Rule 8.4, the selection committee is to be constituted as under. This one, my lord, already I read out from the rules, my lord. Then, my lord, para 11.
You're reading rule 8.1, isn't it?
8.4, my lord, substituted this one.
Non-teaching.
8.4, non-teaching, yes. 8.4. The school selection committee was selected principal.
Eight four, is it?
Yes. Then, my lord, para 11. Having regard to the scheme of the selection to the post of junior assistant under the 2003 rules, as discussed above, it is quite evident that Deputy Commissioner of the concerned district has no role to play in the selection. He is neither a part of the school selection committee nor the appointing authority. Neither has he been assigned any supervisory role. In such circumstances, interference by the Deputy Commissioner in the selection process for the post of junior assistant in higher secondary school and high schools would be beyond the mandate of the 2003 rules. As such, the interference is not contemplated under the said rules. Then, my lord, finally, at para 13, on due consideration and on a thorough examination of the matter, courts of the considered opinion that withholding of appointment to the post of junior assistant in the two schools is not at all justified. On non-existent grounds, the selection process was interfered with by an authority who is not authorized to do so under the law. And having regard to that, the Inspector of Police Nagaon District Circle is directed to act on the respective select list and thereafter issue the consequential appointment orders to the two petitioners, which shall be done within a period of 30 days from the date of receipt of the certified copy of the order. Both the petitions are accordingly allowed, my lord. And for recently also one judgment I will place. Yes.
Basically, appointment are conducted by the state level direct recruitment commission for the grade 3 and grade 4. And yes, this is constituted under the act and it is published in the Assam Gazette. So, my lord, this post may be done to the government's, my lord. So
What is it?
This may be, this post may be gone to the government, my lord, and as there is no stay order, my lord. So, my lord, I may take some instruction regarding that.
See,
Whether
there's
the
a-
post is still vacant or not, my lord.
The vacant post advertisement on that without cancelling the earlier selection process. How can they say that the post is not vacant?
There is no, as per Since it is a no stay order, so that was maybe go to government, my lord.
Why are you saying all this now? After we spend more than half an hour.
Just now I get this instruction that some direct recruitment commission has constituted for the post of class 3 and class 4.
And this was subsequently happened, my lord. This process was initiated long back. At that point of time, no such notification was there.
Heard Mr. R is not on the council. On request made by you, Sharma, and the Secretary Division Department. List after 1 week.
1 week.
But in this matter, we have filed affidavit today, Lord. We have submitted copy and we are filing today, Lord.
You are filing today.
Yes, we have sub copy.
Heard Mr.
R Karim.
R. Karim, on council. For Mr. A. R. Dabildal in the standing council, higher education. Submits that they are filing counter affidavit within the course of the day. Accordingly, list the matter after 2 weeks.
Complex.
17.
Regarding this matter, one second government. And my lord, the exercise will be done.
The
by
mic
the
is on,
government, my
please, your
lord.
mic on.
My lord, pension between two parties, my lord, that will be exercised by the government, my lord, not
Oh.
by the elementary, my lord.
Oh.
So, and my lord, another thing is that there is one certain judgment is also, my lord. Good afternoon, certain judgment.
It will be apportioned between the first wife and the second wife.
Yes, ma'am.
That is in case of Mohammedan law, my lord.
Mohammedan.
But so far as this case is concerned, my lord,
Oh.
As per a recent amendment, my lord,
Amendment.
amendment of the pension rules, my lord.
Oh.
It says, my lord, if the family pension recipient does not divide the amount among the other beneficiaries in equal share, and on receipt of such complaint from the eligible family members, the competent authority shall issue orders apportioning the family pension among the other eligible family members. So in that case, my lord, if both the parties agree, my lord, can be disposed of.
Yes, my lord.
You are the?
I am the mother of the deceased.
And
And
he is the wife of the deceased.
wife and the.
I am eligible, my lord.
Lordship, since this is a law, lordship, it has come up after the filing of the deed petition. So I will have no objection if the mother gets her share as per the. Lordship can dispose it.
Let us see the amendment.
In spirit of that, another, my lord, Pranam Act, my lord. Keeping in spirit that Pranam Act, my lord, that mother share can be given, my lord.
Where's the amendment?
Down below, my lord, section 2, subsection 2, my lord.
It's the amendment of the rule for 143. Subsection.
What is your case?
My lord, the petitioner's son died while he was in service. Thereafter, we applied for the pension, my lord. But that has been rejected, my lord. We filed this petition. It was rejected because the wife of the deceased also claimed for the pension. And we filed this petition before this honorable court, my lord.
Where's this ruling 2018-5 GLT?
I have the judgment, my lord.
387. Yes. Yes.
My lord, relying upon this judgment, my lord, the circumstances are different to my case. I am the mother of the deceased, my lord. There, after this judgment, this amendment has come, my lord. So accordingly, I'm entitled to get the pension benefit, at least 1/4 of the share, my lord, of the pension benefit. That is my prayer. And also, my lord, this the private
Who's getting the pension now?
now nobody is getting it.
No pension.
No pension.
No pension, no pensioner benefits, nothing.
Nothing, my lord. But the scope here is that the pension can be divided, my lord. And thereafter, this amendment has come, my lord. One more point, my lord, that the deceased did not nominate anyone in the pension. That is why, my lord,
Who's respond number 7?
the wife, my lord.
The wife. So you want it equally apportioned?
Mother gets the chief.
You want to get 1/4?
My lord, that can be one
Decided by the pension
authority, my lord.
whatever shares you will get.
Heard Mr.
As Kakotin.
S. Kakutil and the counsel for the petitioner. Also heard Mr. Elementary who appears. MSN Fukan, Leonard Standing Council, Elementary Education for the respondents. 1, 2, 1 and 2.
Yes.
Pension.
I appear for
Mr. G. Bekul, Learning Government Advocate, appears for the respond number 3.
my lord.
And Accountant General. Mr. R.K. Talukdar, Leonard Standing Council, Accountant General, appears for respond number 4. Mr. H. Alia, Leonard Standing Council Finance, appears for respond number 5. And Mr. M. Ahmed, Leonard Council, appears on behalf of the respond number 7. Stop. The petitioner's son, let Ashok Kumar Das, while serving as upper division assistant in Kahia High School at Kahia District Barbita, died on 10/6/2000, died in harness on 10/6/2018. Stop. In harness on 10/6, leaving behind the petitioner, i.e. the mother, and one handicapped brother. Stop. During the lifetime of the said late Ashok Kumar Das, he was looking after the petitioner and his brother. Stop. The respond number 7. Who is the wife of the wife of the late Ashok Kumar Das? Left the matrimonial home in the year 2009 and has been residing in her father's house at Khalijar village, district Barbi. The dispute in the present petition is regard to the pension and pensioner benefits of the petitioner's late son, namely of the petitioner's son, late Ashok Kumar Das. Stop. During the course of the hearing, and also in view of the amendment to the Assam Services Pension Rules 2022, which was notified in the Gazette on 17 August 2022, the parties have agreed to settle the matter by permitting the council authority to apportion the pension and pensioner benefits of the late Ashok Kumar Das in favor of the petitioner and the respond number 7. Stop. Para. In view of the consensus arrived, this writ petition is disposed of. Directing the who is the authority, pension. Director of pension. Director of pension Assam, respond number 4. To settle the matter, to settle the pension and pensioner benefits of late Ashok Kumar Das, who died on 10/6/2018, between the petitioner, i.e. the mother of and the respondent number 7, i.e. the wife of the late Ashok Kumar Das. That much you will do, or you want it more specific? Anyway, that is, we are not giving a direction to you.
My lord, the judgment that is referred to, my lord, is there, it has been specifically divided between the parties, my lord, 50%, my lord.
Then we have the consensus, this writ petition is disposed of. Directing the director of pensions Assam to respondent number 4 to apportion the pension and other pensioner benefits. What are the other pensioner benefits? Death come, retirement, gratuity, leave engagement, benefits, provident fund amount, correct?
Yes, madam.
Group insurance scheme, and area salary, etc., etc. What is it to apportion, no? The pension benefit. So and so.
Party amendment.
In terms of the amendment to Rule 2, to amendment in terms of the amendment of Rule 143 of the Assam Services Pension Rules 2022. That much will do, I think, with the above direction. The petition is disposed.
Twenty-one.
21.
21. 21. May please your lordships. My lord,
My lord, kindly twist the time.
Last occasion also you were given 3 weeks time.
Yes.
But Mr. R. Sharma, Mr. J. Gigul, understanding counsel, regularization is allowed 2 weeks time to file contract.
lordships, the date may please be fixed.
This matter again on 31st August.
I leave next.
22.
My pleasure, Lordship. Your Lordship, the matter relates to provincialization of service, Lordship. Petitioner was appointed on 12 to 1993 as a
Parties are all represented.
Yes, Lordship. Last occasion on by order, there's an office note 27/9/2022, a deemed service on the private respondent. Lordship.
Who is the private respondent?
Private respondent is the Lordship Headmaster of the school, 7. Already deemed served. So notice is served.
Any appearance made? Not yet.
I'm not aware of any appearance. In other way, also under section 14, matter may be remand back, Lordship. Because I am here also aggrieved by the non-recommendation of the district scrutiny committees. Although petitioner as well as the respondent number 7, they are joined on the same day, 12th of February 1993. But under 2017 Act, while the headmaster of the school forwarded the particular, his name is shown against the subject of social science. Although I am teaching the social science, Lordship. Lordship, may kindly come to Annexure 1 and 2 are the appointment letter, page 21, 12 to 1993. Annexure 1. Then Annexure 2 is the Lordship appointment of the respondent number 7, same date, 12 to 1993, page 22. Annexure 3 and 4 are concerned about the permission and recognition of the school. There is no dispute against the permission or recognition. Now, Annexure 5, this is the format duly filled up by the headmaster of the school, that is the respondent number 7. And this was submitted on 5th of June 2017, page 26. Because it is the requirement of the under the 2017 Act that for provincialization of the staff of the school, the head of the institution should forward the particulars. Now, page 27, these are the particulars of the teaching staff of the school. So for the respondent number 7 is serial number 1. He is the respondent number 7, headmaster. And I am the second senior most assistant teacher, that is 2. Nikunjo Gogoi, here petitioner Lordship. Now, thereafter, matter was placed before the district scrutiny committee, and committee has not recommended my name.
So on what grounds?
That ground, Lordship, will find at Annexure 7, page 29.
Yes.
After filing my complaint petition, it was considered by the DO. DO is the member secretary of the district scrutiny committee. May I read this letter, Lordship? This was issued on 19th of November 2018 regarding forwarding of SMC resolution in respect of Santipur ME School recognized. Application dated 12/11/2018. This was filed by the petitioner. With reference to the subject cited above, I have the honor to forward herewith an application in original received from the president of SMC and headmaster of Santipur ME School recognized under the Dhemaji district, which will speak itself. That, sir, as per the prescribed format for provincialization of Bhansari Educational Institution, supplied from your kind and 3 numbers of teachers, namely Surjo Kumar as social science teacher, Dharmendra Gogoi as science teacher, and Nikunjo Gogoi. Initially, my name was forwarded. Nikunjo Gogoi, the petitioner, as language teacher, has been submitted to this office, duly signed by the headmaster of Santipur ME School. This is important, Lordship. That sir, after receipt of the format from the Headmaster District Legal Scrutiny Committee, Dhemaji, has been scrutinized. All particulars of schools and individual teachers, tutors, and found that the name of language teacher Sri Nikunjo Gogoi, that is the petitioner, was appointed on 12/2/1993. And one left out teacher, Sri Sunil Bora, was appointed on 6/11/1989. So the committee has decided to recommend Sri Sunil Bora, who was appointed on 1989, for provincialization of service instead of Nikunjo Gogoi. That's sir, now the President SMC and Headmaster of the Santipur ME School has submitted a petition along with his SMC resolution dated 11/11/2018 for inclusion of name of Nikunjo Gogoi, that is the petitioner, in the recommended list for provincialization of services language teacher. Now here, Lordship, so far the observation made in the paragraph number 2, saying that some Sunil Bora, who was appointed as 6/11/1989. But if we go by the particulars forwarded by the particulars of the school, let's say, again come back to page 25, annexure 5. Here, Lordship, the school itself, the second column, date of establishment of the school under section 311, it is 1990. So before establishment of the school, Sunil Bora was shown to be appointed in the year 1989. And that is the wrong statement given by the school authority. So thereafter, matter was again placed. Now, ultimately, based on this report, this school was provincialized, that is page 30, annexure 8, by this notification, 4th of February, 2021. Ultimately, let's see the eligible name of eligible teachers of the schools are, let's say, published in the official website, that is page 31, annexure 9, serial number 225, 226, 227. And finally, the provincialization order issued on 5th of February 2021, annexure 10, page 32. So agreed by this non-recommendation, I prefer this writ petition. Now, during pendency of this writ petition, I may be allowed to submit a report submitted by the member of the District Scrutiny Committee. That I told you. So during pendency of this writ petition, the matter was again verified by the member secretary of the District Scrutiny Committee. So ultimately, after due verification, they submitted this report by the member secretary to the chairman of the District Scrutiny Committee. Now, subject kindly see WBC number so and so Nikunjo Gogoi, Director's Letter 29/12/2021. With reference to the subject cited above, I have the honor to inform you that the following information in respect of Nikunjo Gogoi, the petitioner of WBC number 3500/2021 as follows. That sir, Nikunjo Gogoi was appointed as honorary teacher in Santipur ME School by the Managing Committee 12/2/1993. There is no dispute regarding the date of appointment of the petitioner lordship as well as the respondent. She joined in the school on 12/2/1993 as per the proceeding book and other relevant documents. That's the district level scrutiny committee meeting that is given. Meeting was held on 4th December 2017 and recommended the name of all teachers of the school, and name of the petitioner teacher was also included in the initial recommendation. Third paragraph, that's a total 3 number of teachers of the school have been sent to the director Assam out of 5 number of teachers on 10/5/2018. The name of Srimati Nikunjo Gogoi has been left out from the list. Now, this paragraph is important, but it is said that Nikunjo Gogoi was appointed as assistant teacher on honorary basis 12/2/1993 by the SMC of the school, and Sunil Bora was appointed as assistant teacher on honorary basis on 6/11/1998 by the SMC of the school. The appointment date of Sunil Bora has been overwritten manipulated as on 6/11/1989, and this is also apparent from the date of, if we go by the date of establishment of the school, because school itself was established in the year 1990, 1/1/1990. and managed to become the tutor of the school, which is reflected in the proceeding book of the school. That sir, the Director Elementary Order Assam has directed the undersigned to place the matter in the District Scrutiny Committee to resolve the submit decision of the District Scrutiny Committee Dhamaji. Therefore, matter is placed in the District Scrutiny Committee Dhamaji for kind information and necessary action. So thereafter also no result is come out from the respondent concerned. And also here also my textbook submission is there is appellate provision under section 14. So taking note of this letter of 8th of February 2022, as well as the earlier letter submitted by the Annexer 7 in the year 2018. So this may be taken into consideration, and after hearing all the necessary parties, let the authority take a final call also. Because apparently, if you go by the report of the district member of the District Scrutiny Committee, the appointment of Sunil Bora is wrong, Lordship, because he was appointed in the year 1998. This 98 is overwritten, shown as 89. So ultimately, his service was recommended. And
Is there a party here?
Sunil Bora, because since there was after filing this petition, I came to know, Lordship. Otherwise, Lordship, I have implemented the headmaster of the school as a party respondent.
So that's fine. But then I think he will have to be a matter party. Supposing if you pass an order which is adverse to him.
Because this development took place after filing
Yeah,
the
I know.
And otherwise also the Sunil Bora may also be heard.
Yeah.
Sunil Bora as well as the headmaster of the school, the district elementary education officer, because she submitted this report. So after hearing all the parties,
Yes.
under section 14, the matter will be disposed of. Otherwise also
Under section 14, it will go to whom?
just a secretary of the administrative department.
Those state level scrutiny committee also
Yes,
did not consider you.
not considered,
Since it was not sent out.
not sent.
Then I think it is the state level committee.
Yes, state level committee headed by the secretary. Lordship. In the
Headed-
appellate
headed-
provision, it
State
is
level committee is headed by the director.
director, but ultimate authority in that they are given the head of the administrative department. So head of the administrative department is the secretary now.
Let us see.
Section 14. Appellate authority, page 123, Lordship. The state level scrutiny committee shall be the Lordship got it.
New one. This everything is gone.
This
1 minute.
yes, sir.
Section 14.
Section 14, page 123. The blue book. Appellate authority. The state level scrutiny committee shall be the appellate authority against any recommendation of the district scrutiny committee. Secondly, second point, and the state government in the concerned administrative department.
My lord, here, director is the chairman, that's for 10.
No, and the state government in the concerned administrative department shall be the appellate authority against
So your grievance is against the state district.
district
committee.
scrutiny committee.
So you should go to the
So
state
direct
scrutiny.
state level scrutiny committee, headed by the director.
Ah,
Here, sir.
Oh,
Director,
yes, yes. Then director may take call.
But they got letter counsel for the petition. Also heard Mr. G. Bekul and Standing Council Elementary Education. For the respondents,
1 to
1
5.
to 5, my lord.
1 to 5.
Deal table.
And Mr. J. Bekul and Governor for respond number 6. Stop.
So far 7 is concerned, notice is served, but he is not appearing. Jim sir. There is a office note 27th of September 2022.
Supper. Notice on the respond number 7. Once deemed to be complete. By order dated 16/12. Stop. However, today also none appears for the respond number 7. Stop. The Santipur ME School was established in the year 1990 under Dhemaji Educational Block and was granted recognition by the government with effect from, where is that recognition order?
Recognition order, Lordship, under annexure 4 is hereby recognized temporarily with effect from 1/1/2005.
And was recognized by the government by order dated
11/11/2005.
11/11/2005. Stop. The school is also captured under the DICE data with effect from 2009 to 2010 onwards. Stop. Para. The petitioner was appointed as second teacher
Yes, second teacher, Lord.
as against the second post of assistant teacher of the school by the
School manager.
headmaster of the secretary Santipur MA School by on 12/12/1993. 93 or 98?
93, Lordship.
93. The petitioner joined to the said course on the same day, i.e. 12/2/1993. Stop. The response number 7. Was also appointed as assistant teacher of the said school by the headmaster of the secretary Sandipur MA School on 12/2/1993. To which post he also joined the said post. To which post he also joined on the same day. Stop. In the meantime, the state government enacted the so-and-so Act of 2017. Within bracket, Act of 2017. And accordingly, the process for provincialization of the services of the teaching and non-teaching staff of the said Santipur MA School started. Stop. The headmaster public respondent 7 of Santipur MA School met the application for provincialization of services of teacher of the tutor with regard to the Santipur MA School on 5/6/2017 by giving the details of the said school. Stop. This is a part of this application.
Yes.
27.
Yes, yes. This is the particulars of the teaching
Along with
staff.
the particulars of the teachers of the said school. With regard to the particulars of the teachers, the response number shown 7 is shown as serial number 1. And his date of joining is indicated as 12/2/1993. And the name of the petitioner appears as serial number 2 as assistant teacher. And his date of joining is indicated as 12/2/1993. Stop. Thereafter, the district scrutiny committee considered the provincialization of the considered the matter and recommended the name of the response number 7 and one response number 7, comma, along with 2 others for provincialization of the services. Stop. Thereafter, comma, SLC recommended, isn't it?
Yes.
Thereafter, the SLC state level committee considered the matter and accordingly provincialize the service of the response number 7. Stop. What is your case against response number 7?
Because he is teaching all subjects, and so far the petitioner is concerned, he is teaching social science. But while the authority issued the provincial order, the response number 7 name is shown against the petitioner lordship as a social science.
The grievance of the petitioner is that the respondent number 7, who was the headmaster of the said school, was teaching all subjects, and the petitioner was teaching the subject of social science
Social science as well as language also.
as and language. Stop. However, comma, the provincialization of the service of the response number 7 was done against the post of social science. Stop. Para. During the pendency of this petition, comma, the district elementary education officer, Dhemaji, addressed to the district commissioner cum chairman, district scrutiny committee, Dhemaji, wrote a letter dated 8/2/2022, and the relevant portion of the said letter is reproduced here and below. Stop. A to A. Para 3 will do? Dekha?
Yes, sir. There are 2.
Stop. I'm just marking it here. Stop. Considering the communication dated 8/2/2022, comma, this court is of the considered opinion that the petitioner should file an appeal before the appropriate authority as provided under section 14 of the Act of 2017. Stop. Accordingly, the petition is disposed of, directing the petitioner to file an appeal before the director of which department?
Elementary.
Of elementary education department, within a period of
10 days, Lord.
10 days with effect, within a period of 10 days with effect from today. Stop. Thereafter, comma, on receipt of the appeal, the director elementary education department shall consider the same by affording an opportunity of hearing to the petitioner, comma, response number 7, as well as
Sunil Bora.
Shri Sunil Bora, and thereafter pass appropriate orders in accordance with law.
I got hearing opportunity.
That is given.
After verification of all relevant documents. Let such consideration be done within the period of 2 months.
2 months we have already.
My lord,
It is apparent that yes.
go to the
Okay.
So let them complete the process.
3 months from the date of receipt of the appeal. With the aforesaid observations of actions, writ petition is disposed of.
Let's be pleased to make an observation that appointment of this response number 7 as well as Sunil Bora may be subject to outcome that speaking order lordship. That
Uh,
authority may be given. Lord.
Okay. The appointment of the
Response number 7 as well as
the
Sunil Bora
provincialization of the response number 7
as well as
and
Sunil
the
Bora.
said Shri Sunil Bora shall be subject to the outcome of the
The
decision.
speaking order to be
Out of
passed
the-
by the director.
Of the decision taken
Right,
by the director.
Let's
elementary
go
education
Yes,
With the opposite observations, directions.
obliged.
23.
May please, your lordships.
Hmm.
Lords, in this matter, the Department of Higher Education is to file their affidavit. Their affidavit would be required in this matter.
I need some time, actually, unfortunately, the file got misplaced, my lord, in office. File got misplaced, my lord. I have asked my friend to, extra, my lord, I'll, kindly some time may be given, my lord.
Yeah, Mr.
As Vishwakarma.
Heard Mr. S. Vishwakarma, Leonard Counsel. On request made by Mr. S. Das, Leonard Standing Counsel.
3 weeks time may be.
Higher education.
Yes.
3 weeks time is allowed to file complaint. Please come.
24.
May please. My lord, the petitioner was appointed as Hindi teacher, my lord, in the year 1996. In my lord, Makri Kolaguru Vishnu Prasad Rava MU school, my lord. And his name has appeared in the my lord dice code for the year 2009 and 10, my lord. But during the process of provincialization of MU school, my lord, under the Act of 2017, the district level scrutiny committee, my lord, recommended the name of the petitioner as additional teacher, and one Provin Kumar Rava was recommended as well as language teacher. Your lordship may kindly come to page my lord 29 and Excel 5. Translate copy, my lord. Page 29, my lord. My lord, here, my lord, Abdul Khalek, science and maths teacher, my lord. He was appointed in the year 2023. Kishore Kumar Das, social studies, 2003. Pravir Kumar Rava, my lord. He was appointed on 2003, my lord. And petitioner, my lord, Konak Sundara Rava, additional teacher, 4/3/1996. My lord, he is a senior most teacher in the school, my lord. My lord, instead of recommending his name as linguist teacher, his name was recommended as my lord, additional teacher, my lord. And subsequently, what happened, my lord? Thereafter, my lord, the director, my lord, on 4th February 2021, the service of this teacher have been provincialized, my lord. Your lordship, my lord, come to, please kindly come to page, my lord, 34, annexure 6. Serial number, my lord, 64, 65, 66. 66, my lord, here, Pravir Kumar Rava, my lord. His service has been provincialized. But the interesting thing is that, my lord, before provincialization, my lord, this Pravir Kumar Rava has been, my lord, expired. After his death, my lord, his service has been provincialized. And in this process, my lord, the petitioner has been deprived from provincialization, my lord.
How do you know that he has died?
My lord, I have, my lord, I have, my lord, submitted, my lord, his death certificate, my lord. Your lordship may kindly come to order dated 21/2/22, my lord. Here, this has been repeated, my lord. I have produced, my lord, his death certificate. Order dated, my lord, 21/2/22, my lord. The order reflects, my lord.
Yeah, elementary who appears. You're supposed to file an affidavit.
Yes. Kindly do it.
Okay, heard Mr.
Zesh, my lord.
J. Islam Leonard Council. Mr. J. Bikul Leonard Study Council Elementary Education. It's allowed 2 weeks time to file contract.
Lord, may I, my lord, to fix the date, my lord.
30.
Obligement.
25.
Lordship, eligible copy of service book received by me, Lordship, only on Monday, Lordship. I sent the letter for instruction, Lordship, sometime maybe later.
You heard Mr.
J. Colita.
J. Kalita, then you counsel for the petition.
Your lordship was sorted, may be fixed.
On request made by MS R. Bora,
RB Bora,
RB Bora, then standing counsel, BTC.
PTC, Lordship,
List the matter after.
2 weeks, Lordship.
After 2 weeks.
26.
26, Lordship, today itself I have filed one short affidavit, Lordship, one paragraph.
One page affidavit, my lord, but this giving oxygen to the illegal appointments. So, my lord, regarding, because the advertise itself is wrong. The whole case will go, my lord. They have to re-advertise, and my lord, in violation of the rule, my lord, they have advertised. So your lordship can direct me to re-advertise and new selection. And her affidavit is only one page affidavit regarding the rule. The government of Assam has filed affidavit that the rule 2003 will be followed, and they have filed affidavit, no, rule my lord, 2018 will be followed. So contradiction between themselves, my lord. So on page affidavit, your lordship can listen, and my lord, unnecessary, your lordship can dispose of the matter, my lord.
Lordship,
Intentionally, they have filed this only one affidavit.
No challenge has been made by the petitioner, Lordship, and she has knowledge, he has knowledge about the advertisement. He has received a copy of the advertisement, Lordship, while public, fully aware by them. Lordship,
I'm not saying that I'm not aware, but it is an illegal. Anyway, my lord, I challenge or not challenge, my lord, the advertisement will go. Please, advertisement to go, because my lord, your lordship will remember earlier, my lord, your lordship asked me also regarding this advertisement is illegal. So my lord, the whole process of selection will go. They have to re-advertise and they have to reselection, made reselection. And we cannot
Where's your
allow.
affidavit?
Advertise was, my lord, no, as per rule, my lord.
What is affidavit today, your lordship?
As per rule, my lord,
Your lordship will fix the letter some other day, your lordship. Today file.
so that he can continue. So that
is
he
not the
can
issue,
continue.
your lordship. That kind of statement should not be made. I cannot be your lordship, argue your lordship. I will have to prepare myself, your lordship. There was supposed to be an affidavit filed, your lordship. If they have filed it yesterday, your lordship, I will have prepared, your lordship. Any day after 15th, your lordship.
And cycle.
Monday it can be fixed, my lord.
MS Sarvi Bora, understanding counsel for BTC submits that she has filed an affidavit today.
No, Lordship, I have filed affidavit today.
You file your affidavit today, isn't that's why I'm saying that she has filed affidavit today. We just need to verify and test the same.
On 14, my lord,
On 16th.
14 or 16?
Yes, the man.
Yes, my lord.
27.
My lord. Well, the last occasion, my lord, the record was to produce by the government, my lord, regarding the. Well, basically challenge the selection of the president of the managing committee, my lord. And the government was to file affidavit regarding this, my lord. As per the reaction, my lord.
Have you filed your affidavit? Respondent 8 has filed.
On 7 as well, my lord. Morning, my lord. Before first of my lord, Pegu told us, my lord, record has received.
Yes, Baro.
Oh, my lord, I'm receiving reports from the inspector of schools, man.
Mr. Pegu, my lord, told us.
No, record is there, method, but inspector of schools record is. The commissioner record is not there.
No, it's same, it should be a same record because your lordship, my affidavit, my lord, page 54, we have annexed that part of the record, my lord. Annexer 7, page 54.
Unless the matter is ascertained by the government, my lord.
No, that's a different issue.
No.
Have you received the full records? No.
My lord, is not there.
I can't hear you.
No, my lord. My lord, only page 7.
No, in your writ petition, but in my record.
No, it is, my lord, it is supplied by the writ petitioner, my lord. Annexer
Maybe
7.
it is by the writ petitioner. This court want to see the record.
My lord. Well, it is a inspector school and.
My lord, let them file it.
Signature.
Let them file affidavit along with all record, my lord,
Well,
the government.
just a moment, 7 and Annexer 54. It is
Yes.
not my document, ma'am. It is a part of the writ petition. It is a part of the record. Annexer 7, page 54. It is a approval of the minister, guardian minister. It is clear there.
No, in your.
Join, no, it is.
The fact
It
is,
a document of the government.
some other fact is also there, my lord, to ascertain the distance of the locality, my lord. That is
That's why
also,
I'm saying,
My lord.
get the records.
Man.
Court, Mr.
A.Y. Chaudhary.
Chaudhary and counsel for the petitioner, Mr. S.R. Barrow, and government advocate shall produce the records. No, to say on request made by S.R. Barrow, and government advocate.
The piece I came in.
I'm sorry, P. Cycle, then government advocate. This the matter after
10 days.
after 2 weeks to enable him to produce the reports.
Obliged.
May I please, your lord?
Mm.
The matter relates to the holding of a temporary in charge headmaster of the, initially it was a madrasa, now it's converted to higher secondary school. Now, Lord, I have been working as a headmaster since 2007. My only lacking is that I had no B.Ed degree. Earlier B.Ed degree was not requirement. Now after the amendment, there could be a requirement. But now the director of the higher education has appointed as 104 to take the charge of the headmaster because he is having a B.Ed degree, B.A. B.Ed. While I was serving 2007 till 2022 as a master degree. Now this is the dispute. However, since he's also temporary, I was also working for temporary. There is no financial benefit, but only the prestigious position, the principal or headmaster, whatever might be. My only prayer before your lordship, since he has already immediately joined because of the direction of the director. So I am out, my lord. Now, since I had been serving last 2007, may I pray that there should be regular selected headmaster?
Till then, he'll continue.
Yes. Post may be filled up with the regular selected headmaster. He is also not qualified.
He has B.Ed, isn't it?
Yeah, only B.Ed degree.
You don't have B.Ed.
I don't have, but I had been serving since 2007.
Maybe, but where's the rule?
Rule, my lord. Assam secondary.
Rule requires B.Ed,
2018.
my lord.
Rule requires that. Rule 14.
Rule
Page
14
35.
requires B.Ed.
Page
35, my lord.
30?
5. Rule 14, my lord. And relevant part, my lord, next page 36. 14(2)(a).
Yes.
That is true. I admit, very outside I have admitted, but I don't have the B.Ed degree. That's why I am outside.
So what is your grievance in the present petition?
Yes, that is true.
What is your grievance?
My grievance was that since I have been working since long as an in-charge headmaster, I should have been allowed to continue my.
As per service rule, as the new service rule has come, the status of the school, earlier it was madrasa, now it is converted to high school, and under it has come under the new rule, my lord. And as per new rule, I have been given the charge because I am the qualified senior most person.
Not senior, I am the senior most.
Qualified, my lord. Eligible,
Qualified subsequently. He
eligible
joined
qualified
after a long gap of my time.
That is the adjective.
My lord, regarding that promotion lawsuit, that
Process is
process has already
initiated.
initiated. Director has already written to the inspector of school to submit those gradually. Lordship has already gone through in another case, Lordship. So that will take some time. Ultimately, that promotion will be given, Lordship, the regular process. It will be completed.
So it's a case of dismissal.
I know,
Dismissing your-
I know the fate of my case, yes. I have honestly, fairly submitted. But what, that's why I'm saying that then let there be a direction that to have a regular process of selection.
Oh. And what is in this IA?
IA was there, they filed, my lord. We
IA
filed
is
that,
a-
I will allowed to continue, my lord.
That is the IA is the.
I have disposed of, no, I'm,
Oh, IA is disposed?
yes.
I they have filed, my lord. IA is only for passing an interim order, but
Interim order.
it was not entertained, my lord.
Heard Mr. S.C. Biswas, learn the counsel for the petitioner. Also heard, who appears?
You, Sharma.
You, Sharma, learn the standing counsel, secondary education. For the respondents, 1, 2,
1, 2, and 3, my lord.
1, 2, and 3. And Mr. B. Purkayasta, learned counsel for the respondent number 4. Stop. The present dispute in the present writ petition, the dispute in the present writ petition is with regard to holding the in charge headmaster of, what is it?
Its full name is, my lord?
Fulbari,
Yes,
Fulbari.
High
Si-
school, ma'am.
Fulbari High School,
yes.
Fulbari High School
In the district of Kacha.
in the district of Kacha. Stop. Para. The Fulbari Senior Madrasa was it recognized?
Yes.
Earlier it was madrasa, now it is high school.
Now, earlier it was the, yes.
Where's the-
Madrasa, my lord,
Where's the order?
it is not there, my lord, that's true.
Okay, cancel it. Stop. The petitioner claims that he is the
Yes.
senior most teacher in the Fulbari High School. Higher secondary school?
High school, high
Now
school.
high
The
school,
Fulbari High School
now holding the charge of headmaster.
is aggrieved by the
Interim
order
order, my lord,
dated
page 16, my lord.
26/7/20.
26/7/2022, by which the respondent number 4 was allowed to hold the charge of headmaster in charge of the Fulbari High School, District Kachar, along with financial powers to draw and disperse the salary, etc. of the staff of the said school. Stop. It is not disputed at the bar that the petitioner does not have a B.Ed degree. However, respondent number 4 has a B.Ed degree in his favor. Stop. Para. Rule 14 of the Assam Secondary Education within bracket Provincialized Schools Rules 2018 provides for the recruitment to the post of headmaster, superintendent, and procedure thereof. Stop. Rule 14(2) of the rules of 1980 provides for the prescribes the eligibility for the post of headmaster, superintendent of in high schools, high madrasa, and provides that the eligibility for the post of headmaster, superintendent in must be BA, BSc, BCom with BT, B.Ed degree from any recognized university. Stop. As the petitioner does not have the B.Ed degree, as provided under Rule 14(2)(a) of the rules of 1980,
2018, rules of 2018.
of the rules of 2018, comma. This court holds that the petitioner has no right to claim for allowing him
In charge
to
headmaster.
hold the charge of headmaster in charge of the said school. And as much as he does not have the qualification of B.Ed stuff. In that view of the matter, there's no merit in the present petition and is accordingly dismissed. Stop. Para. However, comma, it is expected that the respondents would initiate steps to fill up the post of headmaster of the what school? Fulbari
It's a my lord, it is not particular nowadays, it is district wise.
of the headmaster of schools by way of regular appointment,
Regular selection. Sir.
by regular appointment of selection at the earliest.
Well, I may pray that time may be given, but 3 months,
I can't give a time
within 3 months for it.
in view of the order passed today in the mandate petition, I is not disposed.
Offline.
29.
Very fair, Mr. S.C. Biswas. You've been very fair, that's what I'm saying.
Yes.
May pleases you,
Yes,
lordship.
please.
Your lordship affidavit has sent for vetting, your lordship. Can you, 10 days time may be given? to
Okay,
find that?
Mr. J. Patwari, learned counsel for the petitioner. MS,
He does on behalf
P.
of
Das,
Nayak.
learned counsel appearing on behalf of Mr. P. Nayak.
For
learned
PTC.
Counsel BTC submits that the affidavit has been sent for vetting and prays for 2 weeks' time to file counter. Praise a lot. List of.
Keep you.
Interim has to be continued, my lord.
Interim is there?
Yes, 8/8/2022. One post was kept to be vacant. 8/8/2022.
It was not. Interim order passed earlier to continue till the next.
Keep you best.
30.
Please, Lord. Well, matter partner from like non-payment of medical reimbursement bill, my lord.
Yes.
Well, in fact, my lord, referral medical certificate was there, my lord. Everything was there, my lord. Claim was also examined by the Joint Director of Health Service, my lord. Now, my lord, the department in the education, elementary education department, my lord, they are not paying.
No, already we have submitted to the government, my lord. Amounting of rupees 5,63,278 rupees.
With the government. By the directorate.
Yes. That element.
Who appears for the? Which department?
My lord, elementary education department.
Medical. Like to medical for medical college.
Lordship, I'm appealing for the health department. Lordship, the communication made to the health department is of 8th August, my lord. That is, so Lordship, I'll find out as to the status, my lord. We'll have to find out and then we'll sanction them.
Heard Mr.
Yes, sir.
S. Haklan, counsel for petitioner. MS. N. Fukan, standing counsel. Elementary education submits that the directorate
Yes, ma'am.
has forwarded the proposal to the government to accord sanction for an amount of rupees 5,63,278 with regard to the medical reimbursement of the petitioner. Mr. H. Alial, when did you submit?
Lordship, in the instruction last page, there is a letter to the superintendent which is addressed at 8th of August, my lord.
On 8th August 2023. Huh? H. Alial and Standing Council Health Department.
Health Department.
Request for some time to enable him to receive instructions. Praise the Lord. Please, doctor.
Lordship, after 2 weeks, we'll, in the meantime, we'll process the claim.
Yes, ma'am.
32.
May it please your lordship. This case is relating to my lord selection and appointment of principal of Kolaigaon Senior Secondary School. The advertisement was issued at page 32, my lord. So my lord, accordingly selection was held.
To place the record, original record. Record with flag mark.
So selection were held, my lord. But regarding my lord, that is the, as per guideline is at page 45, my lord. So he has been allotted marks in violation of the guideline. Page 45 is the guideline for allotment of marks.
Page 45.
Yes, my lord, Annex 13. That is the guideline, revised guideline for selection of principal of provincial higher secondary school relating to award of marks as per new service rule 2018. So here, my lord, he has been wrongly allotted that
Who has been wrongly allotted?
SCR,
Respondent number 5.
SCR, clause 3, my lord.
Clause 3.
SCR for last 2 years, proceeding of the year. Interim. Here, my lord, the guideline is given the good number 1 mark, very good 2 marks, and outstanding 3 marks. Good 1 mark for good, 2 marks for very good, and 3 marks for outstanding. So in case of that, in place of my lord awarding marks like this, my lord, he has been given, my lord, he may be considered promotion for next promotion. So that cannot be, my lord, that is the only point. That
He has not been allotted marks.
allotted marks, my lord, like this, my lord, that good, very good, and the SCR written has been, my lord, either good, very good, or outstanding. That has not been written. That has been written, my lord, whatever it is, he may be considered for next promotion.
Oh, in the SCR.
SCR. That's why, my lord, no marks, my lord, he was given, I think, 3 marks. That will go. Your lordship may kindly consider the record, my lord, original record.
Connection, my lord, I thought.
And in this, lord, I have not completed. Thereafter, my lord, after going through the record, Honorable Justice Pathak, my lord, he asked me to file an additional affidavit. After going through the record, that is my page 57. Paragraph 4, page 58, that the petitioner further states that the Honorable Court, after going through the record, referred the relevant records to the Council for petition and the Council for the petitioner. After going through the records, both the Council found that the respondent 5, so have been illegally allotted marks by the selection committee in violation of guidelines dated so. He has been allotted mark 3 against SCR, although the marks given in the SCR is not as per norms laid down in the guidelines. He has been given marks. He can be considered for next promotion. So remark was given like this. As per guideline, remarks should have been given as below: good 1, very good 2, outstanding 3. Others are also there in case of the category administrative ability, so on, so on. Others are also there. So I have filed as per direction of the Honorable Court this affidavit.
Yes,
My lord, clarification on this count, my lord. And instruction is right.
What instruction is this?
Madam, this is the verbally instruction I got. my lord.
In support of them, my lord.
3 marks is for outstanding.
Yes. But that is not been written. No?
How can you give outstanding?
That is not sustainable under the law. my- And otherwise also I have got other points also, but this point is the vital point. I got 2 marks.
Where's here?
This year is SP, my lord, 45 for Ravinder Sauri. Page 86 for percentage. The private restaurant. That is right.
And private respondent,
86, page 86.
86. ma'am.
86.
Yes, ma'am.
So what does it mean now?
That is the point of contention matter.
Can you be given marks?
If I may allow. submit. And I appear for the private response.
No, I'll hear you, don't worry. I'm just asking. Can you be given marks with regard to this? You've
Current-
given him maximum again. You've given him 3. Outstanding.
This is how it was interpreted, my lord, by the election after this.
He deserves for next promotion.
Others also,
Because at best, it may be good or very good. But not outstanding.
Even if he is considered very good, my lord, he will
Yes.
score 2 marks.
He's going to get 2 marks.
In that case, my lord, still he will be superior in merit. He is above 2 marks in the final total.
Where's the total marks?
in
Like
total marks also, there are some anomaly. In the affidavit, after saying the records, I have given 2 points. Regarding
Is this the one?
award,
My lord, it is
page
like-
given page at a-
I
70 to 10, my lord. My lord, page 7 to 10,
7.
and relevant portion is 9.
Thirteen and 14, same number. So they become equivalent.
In that
No, my
case,
lord, another point is
if it
also
is
there.
considered good, my lord, it will tie.
He goes out.
Goes out. Because award also, my
Mark
lord,
with him.
award, no. Regarding award also, national award, he has not received any, my lord. There is a, my lord, in page 59, in the affidavit I have written
There
that
is no other.
the petitioner states in category of administrative ability and the respondent has been given 1 mark and the petition has been given 0 marks. As per guideline to measure administrative ability, award 3 marks, national award, state award 1 mark, national award 1 mark, state award 1 mark, and district award 1 mark. He has not received any award from any authority.
Who?
The respondent, private respondent not receive any award, so how he can be given, my lord, 1 mark?
No, where?
In from the affidavit, page 59, my lord. Or if your lordship can see page 45, the guideline, your lordship.
Here it
can
says
see.
whether teacher state national award or awarded by the
Yes.
school students.
1 mark.
It's 0. And he has been given 1 mark.
1 mark. He did not receive a national award, state award, or district award. I also didn't receive. He also didn't receive. But he has been allotted illegally 1 mark. So I'm reading from here, my lord. In respect of national award, award should be given by Government of India. In respect of state award, award should be given by Government of Assam. And in respect of district award, award should be given by the district administration. In case of respondent number 5, he has not been given any award by the above mentioned authority. As such, he does not deserve any mark in that category. Hence, the respondent number 5 has been given 4 marks illegally and violation of the revised guidelines dated so and so.
How
3
many
marks.
posts were there?
Principal,
Yeah.
only one principal,
post
the state school.
of the
So
state
his total mark will be, my lord, 14 only, and my marks will be 16 only.
So who got first?
Basant Saikya, the respondent number 5.
He was given 18
No.
marks.
According to this, there's another person. One Sarvananda Deva Sharma.
That is not the.
Hmm?
It is in different.
He was,
it-
he was,
the one-
Udalguri. The same one.
I couldn't follow one.
No. One person has been given the first position.
No, first position select list, my lord, no position has been given. According to the
Sarvananda
This
Deva
statement.
Sharma. Then comes the respondent, private respondent. Then comes, of course, petitioner.
petitioner.
Then comes one Chinon Nazari.
In the minutes, it is clearly spelled out.
In these minutes.
Earlier, he was teaching only
Phase
50
5,
students.
Hmm.
50 students in the school, my lord, inter school. My school is having 1100 students. So experience is also my matters a
5.
lot.
What is your school?
Following senior higher secondary school. I am teaching 1100 students and his school was having only 50 students.
Oh, this is
Following senior secondary school.
okay.
As from 18, 4 marks will go, then he will be having only 14 marks.
Now,
And-
how is the pattern? How do you select this?
As per page
As per
45.
guidelines, my lord, there is no violation
Guidelines.
of the guidelines.
No.
Except the issue which has been raised later. my lord. This annual confidential report. That apart, there is no.
Award also,
Inconsistency.
award also, he didn't
No,
receive any award.
in the name of the schools, there are different schools.
Yes, ma'am.
Isn't there? There are different schools.
Against my
In
lord,
this select list,
Was taken up together, ma'am.
of course, that is why. It was taken up together. And then on the basis of the merit, you give them the different schools or what?
Different school had different evaluation.
but against
But the-
particular school they apply, my lord. Against particular school they apply.
Oh.
So that is, my lord, although advertised made for 10 or 15 schools, the teachers apply for one school or sometimes two school. Then my lord, school wise, my lord, the members.
School-wise, there was-
sit in a committee.
School-wise.
School-wise never. sir.
No, that is why I'm getting a little confused.
Yes,
This Basanta Saikia, he is a private respondent.
yes, my lord.
Yes, ma'am.
He is for Kabirali Higher Secondary School,
He was working there. He applied for this school where I was working.
Kaligaon,
No, Dhaliya, my lord.
Kalai.
Kolaigaon.
Kalaigaon.
Kolaigaon Senior Secondary School. I am working there.
Oh,
He applied in my school, my lord, and he got selected, and my lord, I could not get appointed.
Election
My
was
school
then,
is having around
election
1100
was done
students,
for that particular.
particular school. Although he was working in different school, he applied for my school. My school is having almost more than 1100 students, and his school was having only 50 students. Small school, my. But he will get 4 marks less, my lord, because he didn't get any award. So award marks, 1 marks go, and my lord, the SR marks will go because it is not as per my lord, guideline of the
4 marks, which
Department.
one? Which one? What are the marks?
4 marks.
The award, he does not have a state award.
State,
National
government of India or any
So he
award.
got one mark on that.
1 mark will go.
Yes.
He has given 1. And 3 marks for the SR because SR is not as per the guideline.
So
So
for
4 marks goes, then from 18, if 4 marks goes, that remains 14 marks. And I got 16 marks. So I should be appointed as principal.
no, that's what is confusing. There are many candidates with 16 marks. Correct. You check up. There are many candidates with 16 marks,
From different school, maybe mine.
different
It's
schools.
for
Different school,
different-
not in my school.
To respond appropriately, my lord, there needs to be a detailed appeal.
Why you are again this school also, my lord?
The council raises so many issues.
Not is raised, my lord. It was actually reserved for judgment.
The main
But by
issue is
mistake, my lord, again it has been listed.
challenging
It was
the
completed, hearing was completed.
main
We are
challenge is
reviewing.
violation of the guideline. And in my respectful submission, there is no violation.
Why not? Those are
SCR.
violation.
Except this SCR part, my lord.
SCR and award,
That is a violation of guidelines.
and award part
SCR
also.
part is a little
Award-
different, my lord.
Award part also, award part.
Guidelines, there is no mention about SCR.
Yes.
In this entire scenario, my lord, what is my mistake? My lord? I have seen that the issue is regarding the annual confidentiality report. The confidential word is itself ineffective. I am
No,
never
that's
aware, my
fine.
lord.
That's fine.
And my lord very well knows that if an adverse remark is given in an ACR, it is required to be communicated to me. So today, as on today, I don't know what is given in the ACR. So provided it is not an adverse remark, it has to be either very good or outstanding, my lord. It cannot be.
Oh, good.
It cannot, my lord, good may fall, my lord, under average category also.
No, no, it's good.
And my lord would see, my lord, I have never been aware of what has been given in the ACR. Had I been aware, I would have challenged it. Had there been a comment that he is recommended for promotion, I would have placed it under challenge, ma'am. Now I have duly applied. My ACR was placed by the authorities before the selection committee, and they have given a particular mark, my lord, against it. Now, your lordship, the learned standing council of BTC has placed one particular oral instruction, a particular letter from the director by hand, ma'am. It is from the director, ma'am. Director has said that the selection committee has done their part. My lord, the selection committee itself, the chairman of the selection committee is a party member. The respond number 2, the principal secretary. Well, let him answer.
Yes.
The moment he answers, my lord, everything falls into place.
Answer, did mistake part answer. They will give.
And regarding the
Yes,
award
sir.
portion, Mandal, I have raised the issue of maintainability also. What marks have been altered by the selection committee, this court cannot sit on appeal over it. And that case has been developed later on.
No, no,
The
this
record-
cannot be, this court cannot sit over appeal. on the selection of the selection committee, that's right. But when we see that there are some discrepancies, then we can interfere.
Discrepancies regarding the ACR, because clearly it is.
Discrepancy with regard to the issue, I'm not going to any other. I'm not.
That's why the principal secretary and the chairman of the selection
Yeah.
committee, let them
Who
answer.
appears for principal secretary? Yes. You are the chairman, isn't it?
BTC is the authority.
Principal secretary.
BTC
Who's the secretary education BTC?
Yes, I represent
it. Then you'll have to file your affidavit.
Who will do it? This
Yes,
is how
file
the
affidavit.
director explained me
Maybe
about.
the director may have said something, but then let the secretary explain. He's the chairman.
Unless
After this
dragging the-
development in High Court, my lord, they sat together, my lord. Again, he was called in, my lord, in the meeting and asked to explain the way he the SCR. Then he expressed his mind. I wanted to give outstanding. This is what he said.
On what basis? On what basis can he give outstanding?
That I don't know, my lord. This is the my lord, happening in the meeting.
Nothing will come out, my lord, again, man. I don't think so. They will have.
Do you want to take a chance or we dispose of the matter?
My lord, I may be allowed to file an affidavit on behalf of the secretary. To
In
explain
that
the
case, my lord, my lord, because so many times matter was heard, it is not, this stay order should be given, my lord. I have got prayer for interim order, my lord. The inspector,
I'm
inspector,
giving him 1 week only.
inspector will run the school. Why should he should, my lord?
But I'm saying cycle and the consequences. The
Let it come on 7th.
respondent number 2, i.e. the principal secretary and chairman of the BTC level selection committee, shall file a detailed affidavit as to how the respondent number 5 has been given 3 marks against his ACR recordings. Let such affidavit to file within a period of 1 week.
2 weeks.
Within a period of 2 weeks.
No, my lord, the date may kindly fix, there is 22nd, my lord,
Yes, the matter on
22nd of August.
2 weeks will be 24th,
Not necessarily that,
That is
pura 2 weeks, there,
28th.
24.
You retain the records.
24. I would like.
33.
May I please, Your Honor, today I have filed an affidavit in position on behalf of respondent of 5.
Also, we will file a reply, Lordship.
Yeah, Mr.
D does, Lordship.
Mr. D does.
1 week time.
also to the petitioner. Prays for 1 week time
1 week time.
to enable him to file reply to the counter filed by the respondent number 5.
Okay.
Prayers allowed, at least after 1 week.
Lordship fixing any date, Lordship.
1 week is sufficient.
Obliged.
34.
May it please, Your Lordship. Lordship, here the name of the petitioner has been wrongly quoted by the state level committee, for who is the petitioner service has not been provincial.
Yes, who appears?
Your Lordship was pleased to pass a similar order on 31st of July, Lordship. I have supplied. Only the name of the petitioner has to be changed. Lord.
Yes,
Eh,
you,
eh,
Sharma. No affidavit, nothing.
But sometime is required, it is my lord, 2023 method. my lord.
Lordship, the director has already passed a speaking order in favor of the petitioner. But as directed by this honorable court, the provincialization has not been carried out. Lordship. That is only grievance. Lordship.
Yes.
We have also annexed the speaking order. Lordship. Page 54 may kindly be seen.
I've seen.
54 annex 11.
Yes.
Well, in the speaking of order, here it is mentioned. Now, matter for provincialization of service in respect of petitioner will be placed before the next SLSC meeting for consideration. Regarding the next meeting, I have taken instruction whether next meeting, when it.
How many times does the SLC sit? Do you have some idea?
SLC depending on the government.
Government.
State level scrutiny committee, how often do you sit? No, for provincialization.
State level scrutiny committee represented by secondary education.
Yes, Sharma.
Yes, ma'am. Well, I have to take instruction.
No,
after
how
some time-
often,
after
how
some time,
often
my
does
lord.
the SLC sit?
Yes, my lord, after some time, I will just call him and get
Do
the.
you know why I'm asking this question?
As per.
Do you know why I'm asking this question? See the order. When was it passed?
Yes, 2022.
8/4/2022.
Yes.
Today is what?
There is 88.
SLC
nine-
does not sit for more than, does not sit once in a year?
Now, we have received an instruction lottery in the group. Lottery may kindly give us this next by Monday. We'll file a affidavit. That will be given. My lord, in the instruction, it is stated that the master degree of Sri Koldan Das, graduate teacher of PB school was not found as per rule. And hence, Sri Koldan Das, graduate teacher of the school
We are not.
was not.
This is with regard to Omar Ali Sheikh.
It Koldan Das case no. Oh, sorry. I thought it is other case.
So, my lord, sometime is required. Take the instruction.
No, you get some telephonic instructions and come back. How often does the SLC sits
Yes.
in a year?
Yes.
After that, I'll pass orders.
Yes.
35.
May I please, Lordship? My lord, in this case, Lordship, the claim of the petitioner for compassionate appointment was rejected on the ground that the petitioner father had no minimum balance period of 3 years service. My lord, that clause has already been struck down by this honorable court, Lordship. And Lordship, after that, Lordship, against that order, Lordship, writ appeal has been filed. But there is no stay order operating in this case. My lord, I have given some one order, Lordship. Our High Court has already disposed of in terms of the order passed by the
Claim
learners.
of the petitioner, my lord. The DLC had, my lord, rightly observed, my lord, because on that point of time, existence of OMS there, my clause 1 is there. His case was rejected in 2017, and he is not part of the death petition. He is not part of the death petition. He has not challenged that particular clause. And 17, my lord, DLC is correctly rejected, my lord, as per the view of the office memorandum, my lord, 1/6/2015. And now 5 years, my lord, he is coming back.
No,
Because my lord, scheme said that within 2 years, man.
my lord,
Even this is the impugn for him, my lord. Definitely he have to challenge it, my lord. That
Why
point
are
of
not
time,
filing affidavit then?
my lord.
Why are not filing affidavit?
No, my lord, we will file, my lord. This is second time, my lord, after the notice. We have
but
taken instruction
notice
from the
was
department.
issued long back on.
We'll file, my lord,
My lord, only
Then please
issue
stand, my lord.
is, my lord, earlier we approached before this honorable court.
Second time,
And
my
this honorable court disposed this writ petition on 3/2/2023, case lawship 33. Directing the authority to place the claim of the petitioner in, provided that if the claim of the petitioner has not been considered. And if it is considered, then communication was directed to be made. After that lawship, this 35 page lawship, this order was, letter was communicated saying that my claim was rejected in the year 2017. And minutes has been provided, that is from page 36 onward.
Yes.
After disposal of the writ petition on 3/2/2023. So,
My lord, that is challenging the minutes from 2017. Whatever is there, my lord, petitioner is very well known because within 2 years. my lord,
Earlier,
they
he
have
has
to
come before this court, isn't it?
My lord,
Then where's that order?
my lord, to page 32 and relevant lawship page 34, that is the earlier order.
that is clear, my lord, very much clear. Once his case has been, my lord, considered, there is no repayment for further places.
Yes.
Number 5.
After that lawship, they have communicated the letter page 35. Saying that DLC has already been rejected on 17/7. Lordship in that DLC dated 17/7/2017. This letter was communicated on 3 March 2023. After that, we filed this
My
report.
lord, direction of this honorable court in this order, my lord, that court has said, my lord, once this case is not considered by the DLC, then you place it before that. We already placed, my lord, and we have done our part, my lord, in 2017.
But kept
No,
on.
no, no, you have done your part, that's fine. DLC has considered the matter. Then what happened? It
Yes,
was
it's my lord.
rejected.
My lord, page number 41, my lord. 77/2017.
17/7/2017, it was rejected.
My lord.
When did you communicate? Page 35. Come to page 35.
My lord.
When did you communicate?
That is, my lord, as per the honorable court order.
Earlier, why they did not communicate? That is why I have.
This is why I'm asking you.
My lord. My lord, if the view of the petitioner is that, my lord, it is the duty of the petitioner because, my lord, he know that within 2 years, my lord, that compassionate appointment have to be given back. The scheme itself.
You are violating your OM instruction.
My lord.
OM indicates that there should be a speaking order and it should be communicated to the applicant.
Speaking order have to be passed.
And it has to be communicated to the applicant. Is it not?
That part, my lord, I have to obtain instruction because, my lord, that part I cannot say.
That part is there.
This is in regards to petition dated
Clause
9/2/2023,
24.
my lord.
Clause 24.
My lord.
As regard pending cases prior to issuance of the direction, in Chittaranjan case, so and so, the authority department need to ensure the compliance of the direction contained in principle 1 urgently. The High Court had fixed 30 September 2010 within which
24D.
yes,
Correct.
My lord, that is correct. my lord.
So you violated this OM again.
My lord, but
You
right now
violated
cannot say
clause.
that is violated, my lord. Maybe there may be communication. my lord.
You violated clause 1. Of course, that time it was not struck down.
Right.
And
No, right,
24D.
There-
Let them consider. Isn't it? It will be better instead of keeping this with petition pending. Third, Mr. M. Khan, Learned Counsel for petition.
But 2017 vacancy, years of vacancy.
Your communication was on the 3rd March 2023. Also heard MS and Fukan, Learned Standing Counsel, elementary education for respondents. 1. State level, you're there?
I am for 2 and 4, madam.
1,
This one.
3, and 5. And Mr. P. Saiga, Learned Government Advocate for respondents 2 and 4.
2 and 4.
1, 2, 3, and 5.
1, 3, and 5, correct?
Yes, ma'am.
And you are 2 and
2
4.
and 4.
Para. The father of the petitioner, while serving as assistant teacher of Balia MA Madrasa, Karimganj, died in harness on 25/6/2015. Stop. Thereafter, petitioner made an application for appointment on compensation grounds on 6/6/2016. Stop. As his case was not considered by the concerned DLC, petitioner approached his court by filing the WBC number 8429 of 2022, which was disposed of by order dated 3/2/2023, directing the respondents to place the petitioner's application for commissioner appointment before the concerned DLC for consideration in its next meeting. Stop. Para. Thereafter, the district level committee Karimganj, in its meeting held on 17/7/2017, rejected the case of the petitioner. Where is that? Your case?
My lord, page 35.
Rejected the case of the petitioner. No.
Page number 41, madam.
Well, rejection is page 53, relevant lordship.
On the ground that,
Sorry, serial number 15.
on the ground that the this is government servant does not have the balanced period of minimum 3 years of service. Stop. The said DLC minutes was communicated to the petitioner only on 3rd March 2023, and therefore being aggrieved, they present with petition. Stop. Para. The close one of the office memorandum dated 1/6/2015 has been struck down by this court in WBC number 1646 of 2021 by judgment order dated 31/2023 as being unconstitutional. Accordingly, the matter is remanded back to the concerned DLC to consider the case of the petitioner afresh on its own merits in its next immediate sitting by keeping in mind that clause 1 of the office memorandum dated 1/6/2015 has been struck down. Stop. with the aforesaid observations and directions to the petitions disposed of.
Much obliged.
36 and 37.
Maybe Lordship. Item number 36 and 37, my lord, are analogous matter, my lord. And my lord, the matter regarding the disputes of my lord industry seniority between the my lord two petitioners, my lord, for holding the charge in charge of my lord headmaster of a MA school, my lord. My case is that, my lord, the my lord, I joined the school earlier than the my lord petitioner in item number 37, and both the services, my lord, provincialized on the same day with effect from my lord 2013. So his case is that since the service of both the petitioners was provincialized on the same date, so it should be the date of birth. And as per date of birth, he is sitting. But joining in the school, I am sitting. And this is the dispute. Earlier, after hearing both the parties, the DO passed the order and allowed me to hold the charge of headmaster. He filed the writ petition challenging that order. And this honorable court stayed the order. Your lordship may kindly turn to page 48, my lord, the interim order, my lord. But it was at page 48. That order was passed, my lord, of 1/31/3/2023. Paragraph 12, last second line, my lord. Page 48. The consequential order under memo number lordship the government. So and so shall also remain state till the next date of listing.
Yeah, who appears?
And my lord, that order was
My lord,
subject
in this
to,
matter, we're waiting for instruction.
That's what you have not filed your affidavit.
Yes, ma'am.
and my lord, instruction is sufficient, my lord. When affidavit is not necessary because my
Let
lord,
him get instructed.
yes, my
Yes,
lord.
Heard Mr.
DA Kaim, my lord.
D.A. Qayyum, then the counsel. Also heard Mr.
R Islam.
R. Islam, then the counsel for the respond number 6.
6.
Mr. G. Vikul, then the standing counsel,
Elementary.
elementary education, education department is allowed. How much time?
2 weeks, ma'am.
2 weeks time to receive instructions.
Lordship may kindly fix the date, my lord, because my lord,
Please, the matter on
31.
31st.
obliged.
Order.
Why is it coming for orders?
Lordship, no affidavit, nothing had been filed, Lordship, since 2020, Lordship. This is the second line of litigation, Lordship.
Notice is complete.
Lordship, it was complete, Lordship, long back, Lordship. They were to file, education department was to file affidavit, Lordship. None of the respondents are responding, Lordship.
Lordship, in this matter, on the last occasion, Mr. P.N. Sharma had appeared, Lordship. Here, Lordship, he has instructed me, Lordship, some more time is required. Some instruction has come, but it was not sufficient.
1 minute.
So, my lord, some more time will be given. I think it Lordship, came on 23 February 22.
Lordship, from February, Lordship, till now, Lordship, they
No, my
could
lord,
not get the instruction, Lordship.
they have
Sorry,
given-
state of affairs, Lordship.
Lordship, they have given, they have given instruction, but it's not sufficient, Lord.
Who are these respondents? 13, 14, 15, 16, 17.
Lordship, private respondents were there, Lordship, two, Lordship, namely, Lordship, they have already been removed from the school, Lordship. But Lordship, some new incumbents have been appointed, Lordship. So Lordship, mainly Lordship, the education department, block elementary education officer, inspector of schools, Lordship, they need to reply, Lordship.
We will reply, Lordship.
How about the new private respondents that they have been?
Lordship, Lordship may pass order, Lordship, they can also file their affidavit, no problem, Lordship, but
You are saying that some have been removed and new persons have
Lordship,
been brought in?
2 persons have been removed, Lordship, and 2 persons have been brought in their place,
Are
Lordship.
they imputed as party here?
Lordship, they are implemented, Lordship.
The new persons?
No, sorry, Lordship, they are not there. They are not there. Lordship may see the order of the deputy commissioner, Lordship. After the first order was issued by the Honorable High Court, Lordship, there was a direction from the Honorable High Court. And subsequently, Lordship may come to page 67. Last portion lordship, that will do. Page 67 lordship.
Yes.
Last big para lordship. In view of the above, I am of the opinion that the engagement of Srimati Dasami Talukdar and Srimati Sitra Deka as cook cum helper by SMC of 6 number Borka Satra LP School was not in accordance with law. And in the same breath, the removal of Bobita Bayan and Dipali Kolita, these are the two petitioners, was not in accordance with the law. Hence, I do hereby order all concerned to take necessary steps to immediately reinstate the petitioners, namely Srimati Bobita Bayan and Dipali Kolita, with all regular honorarium and arrears, and also to release the honorarium which remains unpaid from August 2015 onwards. And also to forward bank account details of the petitioners to the concerned authority for facilitating payments of their honorarium. Meanwhile, there shall be no punitive deduction of any amount of honorarium from the pursuance of a resolution of SMC dated 25/6/2016. But with the reinstatement of the petitioners, Srimati Bobita Bayan and Dipali Kolita, the names of Dasami Talukdar and Sitra Deka shall henceforth be struck off.
Lordship, in this matter, if your lordship sees the cause list, no one has perhaps the service has not been complete because no one has.
That is complete.
Lordship, no one has filed wakalatnama for the private respondent.
So not responding, Lordship. That is what I am saying, Lordship.
So my
They are
lord,
not responding, Lordship, to court's directions or
so
whatever.
lordship, they will be.
Are
they
they
will be
also,
in a-
Lordship?
They will be required. Lordship. In the meantime, we'll file. Lordship.
Lordship may see the Lawazima Court Order, Lordship, 2012-2021. আমি দেখি যে এটা পার্টি করি তো রেসপন্ড করা না একটু আমিও তো বলবো যে এখন না
Okay, heard, Mr. And Bhagwati Learned Council for the.
Lordship, I'm sorry, no new incumbents have been made parties, Lordship. 17 and 18, Lordship. They are 17 and 18.
And Mr.
A for
Learned Standing also.
Elementary.
Elementary education is allowed how much time?
Lordship, 3 weeks, my lord. 3 weeks.
To file counter.
Lordship, let it be for the last time, Lordship. They have been Lordship, may fixing it after 2 weeks.
3 weeks.
I'll enter. Lordship.
39.
TPM.
May I please, your lordship? Lordship, the non-compliance of the order dated 12/21, lordship.
Here the matter has been already been sent to the final judgment for his view, lordship. So we're awaiting that. Lordship. Hearing already been done. Lordship.
D1000, lordship. D1000, lordship.
Council. Learned Council for the petition. On request made by SMT Kishti Learned Council for the respondent number.
1.
Respondent number 1 is the matter after 2 weeks.
Yes, it will take some time. Final lordship, it will be after 3 weeks. And more, respondent 1, he is no longer in service, lordship. That maybe can be recorded, lordship. Respondent 1 is no longer, he is already retired 2 years back. So they have
But
to.
you'll have to implement parties.
A new one.
One. Lordship will
Obliged.
take in you. I'm obliged,
Okay.
lordship.
May I please, your lordship? As per office note, no affidavit has been filed by the government till date.
Why is it coming for orders? Are there any private respondents? How about the notice on respondent 7 and 8?
Your lordship, actually, I don't have any idea about this matter.
Service complete for him.
Service has not been completed.
No. Registry to verify with regard to service of notice on the respondents 7 and 8. And list the matter after 1 week.
41.
It pleases your lordship. Lordship, the respondent is yet to file the affidavit. They sought time last year in July. Probably in June, 10 June.
How about the private respondents?
They have not
Notice-
filed anything, lordship.
Notice is complete,
Yes, lordship.
complete.
Yes, lordship.
Respondents 5 and 7,
Yes, lordship.
or 4 and 5. Oh,
5 and
4
7
4 to
notice is
7.
complete.
Yes. Bukan. Heard MS N Begum. Then the counsel for the petition. MS N Bukan. Then it's semi-counsel. Elementary education is allowed. How much time? 2 weeks time.
Lordship, 2 weeks may be given. Already a year has passed, lordship.
Is
It may be fixed for admission. After that, lordship, finally it may come up for it.
better after 2 weeks.
After
We'll
2
see.
weeks, lordship. Much of
42.
Lordship, in this matter, Mr. Airbuya's name is reflected in the cause list, but Lordship, I don't have any instructions from his side. So Lordship, may kindly, adjourn for the time, for the day, Lordship. Actually, he is right now out of the court, Lordship.
On request made on behalf of Mayor Brian, the counsel for petitioner, list after 2 weeks.
Highly applied.
43.
Taika,
My lord, order of this honorable court complied with.
have you got a copy?
No, lordship. We have not received.
Give you a copy.
I have already.
Huh?
They have informed, but we have not received any copy.
Morning matter.
Yes,
Lordship may fix the matter in the month of September.
forward.
Lordship,
Otherwise, my lord, if you issue rectification made matter, everything matter done.
then it may be closed.
Third MS.
G Swami.
Oh, okay, just like it. MSG Swami and the comfort. That the respondents have complied with the directions passed by this court. Mr. P. Cycle and the council appears for respond number
So let's.
for the sole respond. Condemned petition is according to this.
Obliged.
44.
May I please? In this case, my lord, notice was issued, my lord, for son of 6. And a notice has been, my lord, notice. Services, my lord, completed, my lord. My lord, let the matter come on admission column, my lord.
Yes,
My lord, notice has been, my lord, served, my lord, on the son of 6, my lord, but he has not appeared, my lord. My lord, let the matter come up on admission here, late column, my lord. In the meantime, my lord, let them file affidavit.
Lordship, in the meantime, we will file our affidavit.
A date be fixed, my lord.
heard Mr.
Yes, my lord.
From the comfort. MS
S to T.
S. Tutel and Standing Council,
File. Elementary education.
Elementary Education. Praise for 3 weeks time.
Fine.
File counter. Praise allowed, list up to 3 weeks in the admission column.
Right.
Oh, date may fix.
I'm not saying a date.
45.
May it please your lordship. Lordship, the present application is filed for restoration of the connected writ petition lordship, which was dismissed for non-prosecution on 14th day of March 2023 lordship. Lordship, I was on maternity leave, and when I joined back, I came to know that this matter was dismissed for default. Lordship, if lordship will peruse the dismissal order, neither the advocate representing the petitioner nor the private respondent were present. And government side has also not filed their affidavit, Your Honor, as per the office note. Lordship, I may pray the matter may be restored back, and this is fixed for final hearing, Your Lordship, on admission stage.
Yes, who appears?
Lordship, we do not have any objection, ma'am.
Heard MS,
K. Jain.
K. Jain Learned Counsel for the applicant. By this application, the applicant, who is the writ petitioner in WBC number 2335 of 2020, prays for restoration of the said writ petition, which was dismissed for default for non-prosecution on 14/3/2023. Stop. It is the case of the learned counsel for the applicant that she was under maternity leave, and therefore, when the matter was called up on
14th March.
14/3/2023, she was not present. Stop. Considering the submission rate, the application is allowed, and the writ petition number
2335, Your Lordship,
2335 of
2020.
2020 is restored back to file. In the main writ petition, we have the order passed today in MC number so and so. This writ petition is restored back to file. It's the matter. At what stage was it dismissed?
Admission stage, Your Lordship.
Is the matter after 3 weeks.
Deeply obliged.
46.
Yeah, please, your lordship.
Mm.
Lordship, it's a contempt matter.
Mm.
Order of this court, page number 11, page 11, lordship. And
Before the lordship, my friend has to implement the new secretary school education. The previous study is no longer holding the post lordship. So it is for the first time it has came.
Let me withdraw this and file a fresh.
Instead of issuing notice, it will delay the matter. So we implement
What you can do instead of filing an impeachment application, then filing a application for amended course, you can withdraw this and file afresh by taking help from your friend. Your Miss MS.
D. Datta, lordship.
D. Datta, Learned Counsel for the petitioner, press for withdrawal of this contempt petition. With liberty to file afresh.
File your blame.
Contempt petitions accordingly close with liberty as spread for.
47.
Yeah, please, your lordship.
Mm.
Lordship, the instant contempt petition has been filed for non-compliance of a lordship order dated, my lord, 18/07/2022, my lord, person WBC number 4477/2022, my lord. It starts from page number 17, my lord. Lordship will file the 11 portion at page number 20, my lord.
Page 17.
My lord, the judgment and order starts on page number 17. Lordship will file the 11 portion on page number 20, paragraph 5, my lord. In that view of the matter, the petitioners are directed to file an appeal before the state government against the recommendation of the state level scrutiny committee within a period of 10 days from today. Thereafter, the state government, on consideration of the facts and circumstances of the case, shall pass appropriate orders in accordance with law within a period of 1 month from the date of receipt of the appeal. Till such time, the state government disposes of the appeal. The respondents are directed not to provincialize the service of our respondent number 6 and 7. Lordship will file the appeal at page number 22, my lord. Notices has not been issued at this.
Okay, heard, Mr.
RB Guhai, my lord.
Are we going on the council for the petition issue notice? Petitioner to take steps for service of notice on the sole respondent by registered for in 1 week.
Highly obliged.
This up to 6 weeks.
48.
May I please, Lordship? Lordship, as per the Lodgement Court order dated 26/5/2023, service is completed.
Yeah, here also you are appealing, Jutia.
May grant you and to file our application.
Hertz, MS,
Yes, Ahmed.
S. Ahmed, Learned Counsel for the petition. There is the proceedings of the Lawazima Court dated 26/5/2023. Stop. The notice on this one is 5 and 6. Shall be deemed to be complete.
That may be picked for admission.
Stop. MSS Jutia, then the Standing Council,
Elementary
Elementary Education, praise for
3 weeks time.
3 weeks time to file complaint. Praise a lot. List up to 3 weeks in the admission column.
49.
May I please, your lordship? Lordship, we have filed I for implementation of party lordship. It's a respondent number 2. Earlier incumbent was transferred to the post of secretary lordship. And respondent number 2 is holding the post of secretary. Sri Narayan Gaur.
Heard, Mr.
A. Alim SK lordship.
A. Ali,
A. Alim SK Sheikh.
S. Alim Sheikh, Learned Counsel for the petition, for the applicant. By this application, the applicant is praying for implementation of Sri Narayan IS, Secretary to the Government of Assam Education, within bracket Elementary Department, Dispur Guwahati 6, as party responder number 2 in content case number 529 of 20. On the ground that the respond number 1 on the ground that the early incumbent has been transferred and the proposed respondent is holding the post of secretary. Stop. For considering the submission note, pray for implementation is allowed. I use this post. In the content, in view of the order passed today in the IS so and so, late so and so, be implemented as party respond number 2 in the present content. Petition is directed to file an amended post title within a period of 1 week. Please stop the amendment.
Kindly same order may be passed on 50 lordship. Item 50 lordship.
Let us see who are the respondents. It just cannot file. You'll have to file an amended course title. Only after that I'll issue notice. Same. But the contempt case will be in contempt case number 552 of 2022. Okay. File an amended course title. I'm giving you 1 week time.
Item
Let's go.
34. Admission.
SLST fine. His name was already recommended by SLST lordship. He is the instruction.
My lord, I have received the instruction, and as per instruction, the SLSC recommended the name of Omar Ali Sheikh for provincialization as assistant teacher in Balisar High School under Dhuri district, my lord.
Then
Now it is in the common lordship.
Lordship, there is no concept because page 43, Lordship, this honorable court directed them to pass an order. If the order is in my favor, necessary consequential benefit must be given, Lordship.
page 43 may kindly listen for a moment, Lordship. You know, where the concept of sending it to the government, Lordship, I am suffering since 2021.
There's a certain procedure.
Yes, sir.
You just come from jump from here to here.
Lordship,
There's a
Lordship,
procedure in the government also.
Lordship,
It may take some time. I'm not siding with the government, but they will take some time, but then page 43, let us see.
Lordship, para 4, Lordship. In view of the above, Lordship, it would be appropriate for the SLHC to re-verify the records and especially the recommendation of the District Scrutiny Committee, Dhubri, and incorporate the necessary correction and do the needful. If the SLHC is of the view that, in fact, it had recommended Amar Ali Sheikh, then reasons thereof be stated by passing the order and what happened to Amar Ali Sheikh as recommended by the DHC. The reasoned order be passed by the SLHC within a period of 1 month from the date of receipt of the certificate copy of this order. If the reasoned order is in favor of the petitioner, subsequent consequential benefit be also given to him, Lordship. Lordship, it is in the year 2021, Lordship.
Against it, he has filed a contempt petition. Lordship, that was contempt number 1 to 27
Yes,
of 22. That was filed. So we have appeared there. Lordship, now that SLC has recommended his name, it was sent to the government for creation of supernumerary post has to be created. For that, we have to move the finance department. So the procedure is there, Lordship. What will happen if an order is issued, Lordship,
Lordship,
whether he will get this post, Lordship?
Lordship, the order of this honorable court is clear. I am the senior most teacher, Lordship. My 2-3 of my junior teachers have been provincialized, Lordship. Because of this only a spelling mistake in my name, Lordship, I am serving in the school since 1990, Lordship, in the verge of retirement, Lordship.
Now, without following that procedure, Lordship, how can he be Lordship provincialized in a
Lordship,
month or two, Lordship?
Lordship already
Until
there
the
is the
finance
order
department has to-
of this honorable court, Lordship.
But finance department has to create, put the supernumerary post, Lordship. Only then he can be accommodated there. His case was recommended by the
Where's his case now?
in a government, Lordship, for the along with Lordship petitioner, the 23 number of posts were recommended by the SLC, Lordship, for creation of supernumerary post. It was sent to the government. It is in the government now, Lordship. The SLC has done their part, Lordship. Now government will move the finance for creation of that post, Lordship. Until that.
You want the matter closed?
Yes,
You want to
Lordship.
close the matter?
Yes.
Lordship,
You want to close this matter?
Lordship, if this matter is closed, Lordship, again it will take. Lordship, may kindly have
Okay,
their.
heard, Mr.
I am R. Islam, Lordship.
R. Islam, London counsel for the petitioner. Stop. Mr. Mr. U. Sharma, Leonard, standing counsel.
For secondary division.
Secretary Education submits that the SLC has considered the case of the petitioner and has recommended for provincialization of the service. And the matter has now been placed before the government for creation of a supernumerary post. He therefore prays for how much time? 3 weeks? 3 weeks time to file affidavit. Prayers allowed, list after 3 weeks. Mr. Your good name, please.
I'm that chap.
MZ Child and for the respond number 6.